No, not audible. Are you all happy? Yes, I am also happy in looking at the new faces in Telangana. With the blessings of my parents and my senior, Mrs. Vrinda Mohan, an advocate of Pondicherry, I am here in front of you. At the outset, I thank the Rangareddy Bar Association President, Secretary, Executive members and other senior counsels here for calling me. Justice Sam Koshi has called me the moment your bar met Justice Sam Koshi, a very senior judge. He has called me and said, Chandru, you should come to Telangana. I immediately accepted because I enjoyed lot of love from Nampalli Bar Association last time. I came some 7-8 months back to Nampalli. The Bar Association room was half in this. And after 1 or 2 hours of the session, the advocates started coming and filling the stage also. That much of love they gave, and after that they arranged for a big meeting. Around 1,300 advocates participated, and I think it is in Patel Hall.
Keshav Memorial.
Keshav Memorial College. So Telangana is very close to my heart, and I have planned to complete 4 to 5 acts. But today we will finish Domestic Violence Act. If there is time, we will also go to POCSO. And this is a very democratic class, not like our college. If you want to leave the class, you can leave the class anytime. Or if you want me to finish the session also, you can raise the hand, we will finish the session. In that way, this is very democratic. Okay? Yes. And to my senior advocate. Right? I am a small dust. As any other person, I am also a small dust. Hard work only pays. Right? Please have faith in hard work. Any amount of hard work will never fail. So please work very hard. As an advocate, we should be very, very sincere, very shrewd, very loyal to ourselves and also loyal to the clients. Yes. The topic of the day 2005. I am insisting the word the also. There is a lot of difference between a and the God, the universe, right? And like that, no, the word, the prefix the, THE has got lot of significance. Then comes the word protection. There is a lot of difference between protection and care. See, comparing to this, tomorrow we will be having the Juvenile Justice Care and Protection Act. Here it is not the care of women. It is the protection of women. Okay? What is the difference between care and protection? What is the difference? Anybody? You can give the mic, brother. Now, maybe one of you can give mic. Let it be an interactive session. What is the difference between care and protection? Is there any difference? Yes. Each different word has a different meaning. The topic is analyzed, the entire book is read. Like that, no, if I come to Telangana, if I see a board, and other things. If something is displayed in the board, it means it will be in the care and protection.
Care means the welfare or well-being.
Okay, protection, no?
Protection means protecting.
Security. Save and security of the protection.
Yesterday night when I landed in Telangana, my mother called and she asked, whether did you eat? How is the climate? This is care. Care is out of love. Protection will have a legal sanctity behind. My mother is not protecting, right? See, take for example Modi ji. There are a lot of policemen around. What are they called? SPG. They are not carrying him, right? Who will carry him? His mother will carry, his brothers will carry, or any good citizen will carry. He is our Prime Minister, he will be taken care of, he should be taken care of because he is saving the country. So protection is born out of law. It has a legal sanctity. Care comes out of love. the Juvenile Justice Care and Protection Act, because parents are expected, natural parents are expected to care the child. Adopted parents are also expected to care the child. And law is expected to protect the children. So these two things, every word, my dear, in law matters. If you want to become a very sharp advocate, you should research on a small full stop, comma, a colon, a semicolon, anything in the paper, in the law. You should have a very sharp vision like eagle eye to first question yourself why there is a comma, why there is a full stop, why there is a colon, why not a semicolon. Then you should, every one of us should have a book called as Interpretation of Statutes, right? Interpretation of Statutes. There are a lot of books. Go to the library and see, you will be astonished why, even for a small full stop and comma, there is a lot of difference. Okay? Now the word the we have seen, protection. Now come to the word woman, the protection of woman. Who is a woman? What is the age for a, what should be the age for a woman?
She is a female, she is a woman.
Srinath sir has given me a dairy milk. It is like this iPad size. Yesterday night he gave. I have got it here. If anybody is going to say correct answers, then I will give that. It is a dairy milk with nuts and what? Fruits. Right? Yes. Tell me. The protection of women. What is the age of a woman?
18 above.
18 and above. What is section 10 of IPC?
Any woman, any age.
A female of any age is a woman. Right? My mother, during her delivery of me, she has delivered a man. My mother has delivered my sister. My mother is a woman. She delivered a woman. Woman. As per section 10 of IPC, my mother, a woman, delivered a woman. So the word woman in legal context do not have any age barrier, age restriction. We generally think woman should be elderly lady. Even if you ask a 30-year-old girl, no, she will say, no, I am not a woman. A 60-year, my mother also do not want to call as a woman. If you call my mother as a girl, she will be very happy. Like that also same to men also. Even a 70-year-old person will think he is a boy. He will also wear a jean and a t-shirt. Right? These are all some disturbances of the mind. Don't worry. Right? Now, the protection of women. So you have understood that woman has a legal sanctity out of law. Law has provided certain protection to women. There is no age. Which woman will be protected? Every woman will be protected. What is the criteria? Female. So don't phone call and ask somebody whether I can file a case for mother-in-law, whether I can file a case for grandmother, whether I can file a case for an adopted daughter. You understand, my dear?
Yes.
So we will understand things very sharply. The protection of women from domestic violence. This word domestic also is very dangerous word. Right? If it comes to animal, we can categorize. Dogs are domestic, rabbits are domestic. Right? If I ask the wives of all these men, whether these men are domestic, I do not know what will be the answer from Home Ministry. Same thing if I ask your husbands here. They will say, no, she is like Patrakali, sir. You human beings, we cannot categorize whether they are human, whether they are wild, whether they are domestic. But law says protection of women from domestic violence. If there is domesticity, there cannot be violence at all. In fact, the word should have come like this: protection of women from wild violence. See, domestic is humanity. See, what is a domestic animal? Rabbit is a domestic animal. Whether a tiger is a domestic animal? No. A dog is a domestic animal. Sometimes dogs also bites. Right? So now the law says protection of women from domestic violence. It means in the home. A true home should be a true home. But how many of us wants to live in a true home? We are champions of creating problems. Mind is very complex. Right? We live in either in imagination or in suspicion. two things creates problem for every woman and man. We either imagine things or we suspect things. The relationship is spoiled because of these two things, and we are worried too much about the future things, not what we have in the present. Right? If I don't have a child, I am worried. If I have 2-3 children also, I am worried how to take care. Right? If I am not married, I am not sleeping. If I am marrying also, I am not sleeping. Before marriage, I go to astrologer. How to get married, whom to get married, when to get married. After marriage problem, go to astrologer. Then I will divorce. Which judge I should go and approach, which advocate I should engage. If you want to make life as a problem, it will be a problem. You should always think it is a matter of 36,500 days. If you live for 100 years, it is only 36,500 days. Right? It's a small life. There is no big issues in that. And as advocates, you should have a very clear mind, very happy mind, because then only you should solve other man's problem. As a doctor, if I am sick, how can I cure the patients? So an advocate always should be problem-free persons. Right? Those advocates are very efficient advocates, effective advocates. So my first prayer to Telangana Bar Association is please don't fight with your wife. Right? The same thing to you also. And don't invent new lovers also. That is the greatest problem in life. It will look very green, but it will turn black or blue immediately. And your wife also knows wives are like CBI officers. If you enter into any love affairs, then she will catch you. Then instead of being advocates, we should be like litigants. Okay, so the Act now says the Protection of Women from Domestic Violence Act. Now the word violence is also very important, my dear. This word violence should not be equated with the word crime, C-R-I-M-E. If it is a crime, then it is through a registration of FIR, things will go. Any crime under the land will be governed by registration of FIR under section 154 of CRPC or 173 of BNSS or 200 of CRPC or 223 of BNSS to a magistrate. See, there are two roads. One is a village road, old road, CRPC. Right? Section 154. Through the police. Another is in CRPC itself to the magistrate. Any person can set the criminal law into motion either under 154 CRPC or under section 200 if it is under the old code. Or a crime can be set into motion under the new laws either under 173 BNSS by registration of FIR or under 223 of BNSS by registering a private complaint. Okay, now this act says, the nomenclature says, the protection of women from domestic violence, V-I-O-L-E-N-C. This violence is not crime. If it is a crime, then the Person in Domestic Violence Act will not be called as a respondent. Here, she is the aggrieved person. She is not complainant. If she is a complainant, then it is a complaint under section 2 bracket D CRPC. If it is a complaint, please understand very carefully, my dear. I do not know how much you are equipped with the knowledge. If you don't understand, kindly in tea time you ask with me, I will explain. Right? I have come all the way at the invitation of all seniors here. If you don't understand, then I am the failure, not you. Right? Please understand everything, very simple things, very deep based things. Right? If it is a complaint, if Domestic Violence Act is a complaint, then she becomes a complainant under section 2D of CRPC. It becomes a complaint under section 200 of CRPC. Then magistrate has to take sworn statement. Right? So, a Domestic Violence Act is set into motion by way of an application. Understand, my dear? It is not a criminal procedure. Institution of an application under section 12 is not a criminal institution. It is not an institution of criminal law. It is an application filed under section 12 along with interim applications under section 23. Both are applications, right? Since it is not a criminal law, since it is not a criminal action, there is no framing of charge. Firstly, there is no recording sworn statement. Okay? Yes. You should, suppose a question is asked, whether institution of a domestic violence action is a criminal action. No. Why? Because section 12 says an application to magistrate. 23 says application for ex parte or interim reliefs. What is an interim relief? Main relief is under section 12. Other reliefs are section 17 speaks of shared household. Section 18 speaks of protection order. 19 speaks of residence order. 20 speaks of monetary relief. 21 speaks of custody. Whether this custody is permanent or interim. Please note, you can never have a permanent custody under DVC because custody is governed by what law? Guardians and what act? Please note down, in a proceeding under Domestic Violence Act, interim custody alone can be obtained by the woman. Because woman is the petitioner, woman is the aggrieved party. Section 2A says a woman can be, aggrieved person is a woman, she can be the petitioner. Right? It speaks of two orders. Right? Then 21 is custody order, 22 compensation, 23 speaks for obtaining ex parte reliefs or interim reliefs. So ex parte means in the absence of the person, right? In the absence of the other side. Ex parte means in the absence of the other side. Either before his presence or after servicing of summons, that fellow would not have appeared. Or if the relief is very, very urgent also, you can ask the court, for example, a residence order, right? Chandru marries Chandrika. For convenience sake, don't imagine anything. Right? Don't call somebody in my home state and say that this man came to Telangana and married a woman called Chandrika. Fortunately, nobody here Chandrika, no? Yes, thank God. So Chandru marries Chandrika. Okay. Men are capable of acting as if they are loving and throwing women out. You accept?
No.
Very good people in Telangana. I should go and see tomorrow the morning the Telangana family court. Right? So Chandru has driven Chandrika out. She goes tomorrow morning to a domestic violence court, magistrate court, files an application for residence. If the court says you come after next month, if it adjourns the case for a month, imagine the fate of the lady. That 1 month where she will be? Will she be in the street? So the law says ex parte orders also has to be given if the court feels that there is merit in the application. Interim reliefs are not main reliefs. Main reliefs are provided under section 12. Interim reliefs are provided from 18, 19, 20, 21, 22, 23. What is 24? Free copies. 24 says free copies should be given to the complainant, that is aggrieved person. The respondent, word used is not accused, my dear. You understand? Why it is a civil law? Word used is she is an aggrieved person. She files an application. There is no sworn statement. It is not a complaint. There is no framing of charge. There is no framing of charge. Because there is no framing, because there is no framing of charge, husband cannot come and file. Because there is no framing of charge, in any case what you will do? You will file a petition for discharge. Because there is no framing of charge in DVC, there is no question of discharge. The magistrate can write one word order for that without wasting time. Why? This is a civil proceeding. He is not called the accused. She is not called the complainant. no framing of charge is mandated, so I am not entertaining the discharge. You understand, my dear? Then coming to 24 free copies. Under Domestic Violence Act, you need not file anything. You tell your respectable honorable magistrates that there is a mandate in law that free copies should be given to the aggrieved person, to the respondent, to the concerned police station, to the protection officer. Right? Any magistrates are following this? Should follow. See, for all this, the Bar Association is there. It is the duty of the bar not to fight with the judge, because judge is also our family. If advocate is rich in law and we are not to fight, we are just to tell them, plead them that this is the law. And we should convince them. All these are very creative things, because Parliament has taken the pain of telling all this, making a law. If laws are not executed, implemented, then it is a joke. Why it is all made? Parliament imagines, visualizes that a woman undergoing domestic violence will be in a penury. She will not have any money, even for filing copy applications. Right? They believe that we advocates also will be very lenient, sympathetical towards that woman. We will not collect money for applying copy application. Okay? That is other part of the story. Let us not go into that, because I am addressing the bar now, not the judges. Right? Yes. What is section 25, my dear? Section 25 speaks for what? Alteration, modification, like order 9, rule 9, order 9, rule 7, order 9, rule 13. This is the question. Jot it down. Is there any provision in domestic violence for filing an application for setting aside, like the one similar to order 9, rule 7, order 9, rule 9, order 9, rule 13? All this also should tick in your mind, because see, from 17 provision we have come now to 25. There is a provision under 23 for obtaining ex parte or interim order. 25 says it can be modified, it can be varied. It never said there is a provision for setting aside. You understand, my dear? Yes. Coming to 26, it says alternative reliefs. Suppose a husband and wife is fighting before a civil court for some property issue, right? Domestic violence application, she can file there also, but she cannot file section 12 there. Interim reliefs can be filed before any other courts. Main application under section 12 can only be filed before magistrate court, because section 12 says application to magistrate. Section 12 application is like a plaint, my dear. All these 18, 19, 20, 21 and all are like IS, interim applications. Understand? So the main case under section 12 can only be filed before a magistrate. Interim relief can simultaneously be filed before any other forum. For example, I am fighting with my wife in family court. I have applied for a divorce, right? She has instituted a domestic violence case in a magistrate court. Magistrate is a sleepy man there, for example. He is not giving any relief. Family court judge is a fast track judge. She is giving all release fatafat. Now, this wife, no, she can also file one application here before the family court, asking for a residence order, asking for a custody order, asking for protection, asking for monetary. Only duty is, section 26 says, alternate reliefs can be sought for, but she should inform the other court. Suppose family court gives a maintenance of 5,000 rupees. Magistrate also can deal with the maintenance now under the Domestic Violence Act. Only thing is, while passing final order, the party should tell, I have been given already 5,000 rupees there. So deductions will be made in the order. So a wife has got a right to litigate in alternative forum also. This is section 26. 27, jurisdiction, my dear. Beautiful provision. A woman can file a case anywhere in the country. See how women are powerful. The caution is, be very careful before marriage. Think twice or thrice. Should I do this? Right? She can marry you in Telangana. She can go to Jammu Kashmir, DVC application will come. You cannot challenge cause of action. 27 says, wherever she resides, wherever she is employed, wherever a woman is a petitioner, if a woman is a petitioner, irrespective of cause of action, she can go and throw a petition happily, and you will see the taste of it. Right? I will tell examples. Chandru married Chandrika in Kanyakumari. That is Kanyakumari. That is the end of India. That is the end of the life also. Right? End of India, you go and marry this Chandrika. Matrimonial home is my hometown, Pondicherry. After marrying there, I took her to Pondicherry for some time. Some beatings were given to her, 1 or 2 slaps only, along with some kisses also. But which will come in the domestic violence petition? No kiss, no hug will come anywhere. Right? Even if you give 100 kiss and 1 slap, 1 slap will come. Right? Then what will happen? Then I took her to Madras, where I am practicing. Right? Then she came to me along to Telangana also for 3 or 4 days. Then we went to Pune. Right? She went to Calcutta. Thereafter she went to Jammu Kashmir. Now this Chandrika lady can file in any place, or tomorrow morning if she comes, if she thinks that she should go to Punjab and Haryana, she can also go there and send a thing. Only thing is, she should tell the court that I am temporarily here. That's all. One affidavit will do. She need not show anything. Even if she goes to undergo, if she wants to undergo any course, that is studying something and all, anything, she can go anywhere. Okay, one judgment is, please read the judgment. Rupali Devi versus State of UP. Rupali, R-U-P-A-L-I. Rupali Devi versus State of UP. 2019 judgment. Right? I should not turn to your side. What will happen previously? No. See, you should think from the side of a father. Right? I am addressing to this gathering that women are not tissue papers. Right? Taking it from somebody's family, nicely using it, and throwing it in the dustbin. They are not, see, we should respect women. Any country which doesn't respect a woman will never progress. Any country where woman is respected, woman is kept very happily, that country alone will progress. So we are not, I don't want to use any words. We are not, I cannot even say animals, because animal also loves the woman. Right? They are counterparts. And they should be respected. See, we are all products of woman, no? My mother has begotten me, and every mother has taken pain in begetting the children. And begetting a child is not a small thing. Yesterday night, Reena sir came. We were there until 12:30. I ate some more curd rice. The whole night I am pregnant. I cannot sleep. Even one more handful of mouth food is creating trouble. Look at this woman carrying 3 kg or 4 kg of children in the stomach for almost 10 months. At least for that we should respect the woman. And I always support women, don't worry. I will not support you all. I am with them, they are like my mothers. Right? In Rupali Devi says, section 498A, what is 498A IPC? Causing cruelty and harassment to the woman by the husband or relatives. Rupali Devi says 498A ingredients and ingredients of DVC, domestic violence, are one and the same. It is like a idli mav. What is idli mav? Idli batter. She can also go to the police station and put a uttapam, FIR. With the same content, she can also put idlis. Rupali Devi says the ingredients of domestic violence are similar to that of 498 IPC. If she chooses a forum to come to magistrate court, it is a civil forum, that's all. Section 4 and 5 of DVC says every magistrate has got duty to inform her on receiving this application that this content exhibits ingredients of 498A. You have got an option either to make a complaint under this thing first. Ingredients, two things are made out. Criminal to be with the magistrate, then it is civil law. Second cause of action, irrespective of the domestic violence, a journey which starts in domestic violence will end in senior citizen, then registration of Birth Act and Death Act will come. I am not joking. The litigation will take 20 years if the magistrate or the judge is not very sincere and sensitive. I hope judges should have been here also. If there are some judges also, it will be very useful. Judges should think that they are gods, G-O-D-S, to guard the system, G-U-A-R-D. Judges should not be like stone gods. You make any prayer, you will sit like this. Are there judges like this? Yes. There are. But system runs because of few sensitive and good people. This nation is running, every nation is running because of good people. There are a lot of good people. There are a lot of sensitive people also. Okay. So, we have come up to 27 jurisdiction. And 27 says, order obtained is enforceable throughout the country. This dear girl from some cars, no, it has got some speed breakers. If you drive after 60, 80, it will give some alarm sound. Like that, I think if I am raising my voice or turning some direction, it is doing like that, some shake. Right? Where did I leave it, ma? Orders are enforceable throughout the country. Unlike in civil law, you get a decree, then you have to make a transmit decree, then you have to beg everywhere in the country. This orders, if she get an order in Jammu Kashmir, that magistrate will say this can be executed by the police in Kanyakumari. Section 27, 1 and 2 are beautiful. Please read that. Jurisdiction. It is anywhere she can file a case. 27 subsection 1. 27 subsection 2 says enforceable throughout the country. Coming to 28 subsection 1 says CRPC is applicable as procedural law. Right? Like 125 or CRPC. 125 CRPC is not a criminal law. 125 CRPC is a maintenance proceedings conducted by a criminal court, by a criminal procedure for speedy relief. Right? Like that, Domestic Violence Act is also a civil law. I have told you she is an agreed person, he is a respondent. Right? No summons or warrant can be issued. It is only a notice under the Domestic Violence Act, Form 7. Any act for that matter, my dear, you should read the act, you should read the rules. Along with the rules, you should read the forms also. Every act is like a husband. Rules are like the pathetic woman. Implementation. Right? You go to the shop, purchase something and throw it. Whose business is to cook and nicely give? Their business. Then what you will say? You will put marks. Very shabby today. 0 marks. Because while coming to home itself, you will eat fully. So you will put bad marks for them. Right? Then 29(8) says, 28 subsection 1 says about CRPC procedural law. 28 subsection 2 says magistrate court can follow any procedure. See, in no act you will see like this. 28 subsection 2 says, because this law is a socio-welfare legislation, non-availability of a provision should not hamper rendering of justice. For example, we will go to Chandrika's example once again. Chandru has driven this lady out. She goes to the court. Judge says, you go and reside there. What is the order? Residence order. And she comes with the residence order. Chandru has put a huge lock, this much size lock. She goes to the police station. What police will say? Amma, it is locked. Amma. There is no provision. Reading domestic violence, there is no provision for break open. The residence order is not to reside in the platform. Residence order is to reside inside the house. Now 28(2) will come. What 28.2 says? Court can follow any procedure. It should not say there is no procedure. So 28.2 is a great tool in your hand. If you appeal to the wife, you should always think of 28.2. If court says, how can I do? How will I do? What is the remedy? 28.2. Trouble the courts legally, not fighting. With law, trouble the courts. Then only new laws will come. Okay? This is 28. What is 29? Appeal. We'll come to that a bit later. 31, 32 also will come a bit later. Now we will go to violence. I have left with violence, right? Violence is not crime. Violence, in domestic violence, is abuse. A-B-U-S-E. For understanding this, you should remember the word weep. If you torture the wife, what she will do? Weep. What is the spelling of weep? W?
I-P.
E-A-P.
I-P.
E-P. Okay, weeps. She weeps. If you continuously trouble, she weeps. If you trouble one time, she will weep. Right? Yes. Take that double leave and put we. Weeps. It is verbal abuse, economic abuse, emotional abuse, physical abuse, sexual abuse. Right? V-E-E-P-S. Right? This is section 3. Yes, my dear? In domestic violence, there are only 5 types of abuse. That is weeps. V, E, E, P, S. Verbal, emotional, economic, physical, sexual. Okay, now we will come to men's side for some time. I have spoken enough on your side. What is the remedy for them? What is the remedy for them? Is there any law? No law. They should weep in silence. They should pray in silence and cry in silence. Right? It is a general belief that in a society like ours, men are very powerful, men are capable of harassing women. Is it true? These men are very good people in Telangana. They have not said no. No. Only one no is coming. See, there is a provision in Constitution which is Article 15, Article 3. Article 15 says, Article 14 says, equality of law and equal protection of laws. What is equality of law is, in the eyes of law, Chandru and Prime Minister of the country, Shri Narendra Modi ji, both are one and the same. But Chandru is walking alone in the streets. Sometimes rarely dogs will come behind. Narendra Modi ji is walking with a lot of protection. Then where is Article 14? Chief Minister is going with a lot of cars. Chandru is coming in metro. Is it violation of Article 14? No. Equality before law is, as a man he is equal, I am equal with him. As a dignitary, all chief ministers are ranked in one this thing, right? Yes. All women are ranked in one cadre. All pregnant women are eligible for certain this thing. See, Chandrika becomes pregnant because of Chandru. But Chandru is not entitled for maternity leaves. She will be given 21 weeks. I think it is 21 weeks now.
Yes, sir.
More than that. It is now 6 months. No, more than that. New law.
After that also.
6 months. After that also. Chandru cannot go to court and say, Chandri, you are giving Chandrika 21 weeks leave. It is because of me only she has become pregnant. Give that, extent that. Because law says equality before law, equal protection of laws. That is, all women are equal. All children are equal. Children below 12 are equal. Children below 12 to 14 are equal. So categorization, law protects. That is, equal protection of laws means among certain categories, positive discriminations, law will apply to them. For example, all chief ministers are entitled for certain protection. Right? Union ministers are entitled for certain protection. Right? Like that, if you want to come into High Court, you should come through all this check. If a PP or CP wants to go to the High Court, it is all a privilege for the post, right? But law will not discriminate. If the chief minister of a country commits a murder, we will protect. Law will say we will put them down from the post and everybody will be treated equally. So equality before law means as individuals, as human beings, they are all equal. If it comes for Google Akka is telling something, ma? If it comes to categories, paternal leave, maternal leave, benefits, workman compensation, every individual, every group of persons will be given equal protection. Okay. Coming to 15, 15 says there shall be no discrimination on the grounds of religion, race, caste, sex, place of birth. Right? Re, ra, case, P-O-B. You can note it down like that. Re, Ari, Re, Ra. It is not a Telugu song. Re, Ra, not like that. Okay. Re, Ra, case, P-O-B. Re is religion. Ra is race. Case, C-A. Caste, S-C. Sex, P-O-B.
Place of birth.
Yes. Re, Ra, case, P-O-B. 15 says, no person shall be discriminated only on the grounds of religion, race, caste, sex and place of birth. However, it says discrimination can be made which is called as positive discrimination. Article 15 speaks of positive discrimination. Okay. Suppose Chandru is 55 to 60 kg. Right? After coming to Telangana eating all this spice, you will imagine dysentery starts. Right, because of this hot chili. And what is your name, dear? Mallesh. Mallesh. We both are having dysentery problem. Taken to hospital. Who will be governed more? Tinni Boni Chandru or Mallesh? Mallesh is like Mallesh. Now doctor will say, attend to Chandru immediately or he will die. Why? The weakest will be given better treatment. Every law will attend the weakest in a civilized society, right? Like that 15 says, women, children, aged people, scheduled caste and scheduled tribe people deserves more better treatment because then only you can raise for equality. That is the reason all these special laws came. Understand, my dear?
Yes, sir.
If there is a question on any, why all this special treatment to special category, that is Article 15.3, then only 14 will come into effect. If 15.3 is not there, speaking for equality in the air, nothing works out. Right? If you have to make a man who is very weak, bulky fellow, then you should reduce the food that is given to Mallesh and increase the food that is given to Chandru. You understand, my dear?
Yes.
Yes, this is Article 15.3. So, coming to the caption, the Protection of Women from Domestic Violence Act. I told you, along with every act, there will be a rule. Either it will be a central rule or state rule. Only if you read the rules, act will get fulfilled. Otherwise, act will be like Chandru. There should be a rule for every act. Some acts, like Immoral Trafficking Act, don't have a rule. I do not know whether Telangana has got an immoral trafficking rule. But otherwise, it doesn't have a rule. 99.99% of the acts will have a rule. Rules will implement. Right? Whatever the act says, rules are for effective implementation of the act. Forms will give you the form for summons, issuance of notice, all this. Okay? This is the overall view of Domestic Violence Act. Okay? I will ask some questions, you should answer now. On whom a case can be filed in a Domestic Violence Act? On a man or a woman? Any. Excellent. Who said any? Excellent. Can a woman file a case on a minor? No. You said any.
Yes.
You said any. You cannot see. Suppose Chandrika is harassed by Chandru's younger brother, 16 years old. She is teasing. She can also add the elders in the family as guardian. She can sue him also. Protection order can be given to him. That you should not tease her, you should not trouble. Emotional abuse is also there. Okay. For that you should read judgments I will tell. Right? Hiral P. Harswara versus Kusum Narottam Das Harswara. Hiral P. Harswara, H-A-R-A-L. Hiral P. Hiral dot P. dot Harswara, H-A-R-S-O-R-A. Hiral P. Harswara versus Kusum Narottam Das Harswara. Kusum, K-U-S-U-M. Narottam Das, N-A-R-O-M. T-O-M-D-A-S-S. Narottam Das Harswara. It is a judgment by Honorable Justice Rohinton Nariman, Supreme Court judgment. Okay, where he says respondent can be any person. Previously it was believed, now also in Domestic Violence Act, if you add a woman, then the the respondent will come and say, counsel will come and say, no, it should be only as against a man. DVC can be filed as against any person. It need not be that it should be only the man. It can be filed as against any man, right? It can be then filed for the protection of any woman. Okay, now we will come to categories of women in the home. You tell me what are the categories of women, because it is for protection of women. Who is the first category of women?
Minor.
Grandmother. Okay, next, mother. Next, sister. You are just going to outside family only, you are forgetting the grandmother, mother, grandmother, mother, elder, younger sisters. This is one category, right? Then daughter, adopted daughters. So you finished your family. Grandmother, mother, elder, younger sisters, daughter, adopted daughters. Finished. Come this side. Mother-in-law, wife, right? Sister-in-laws. Then mother-in-law, wife, sister-in-law. All these persons can be aggrieved person. Now I am talking about protection of women. Which woman? Grandmother? Yeah, this side over. This side? Mother-in-law? Another important category is live-in relationship. Okay. Suppose Chandru has got married 20 years back, Chandrika, right? A new Rexona or Lux will come to the office as a typist. She will look more beautiful. Right? What Chandru will do now? Read Domestic Violence Act, live-in relationship. This concept is very attractive. So wants to do an experiment with that. Then only you will not become an advocate, go to court. Because Chandrika will fight. No. Right. Now, to make the long story short, in India, there is nothing called as live-in relationship. Read. In domestic violence, if you read, there is a concept called as live-in relationship. Don't get deceived by reading that live-in relationship. For live-in relationship in India, one essential condition is you should either divorce the wife. Understand, my dear? Yes. If you want to have a live-in relationship, it is not +1. You should minus that 1 to make this +1. In India, it is called as live-in relationship in the nature of marriage. Legislature, very technically, right, have designed the word live-in relationship in the nature of marriage. They have added a tail to that. If it is only live-in relationship, then we are all very happy. Wife one side, live-in relationship multiple, all this side. Law says live-in relationship in the nature of marriage. Supreme Court has interpreted it and said that Hindu Marriage Act is staring at everybody's face. Why? Hindu Marriage Act says only for what is that? Polygamy or monogamy? Monogamy, ma. Yes, see, you should have only one spouse. Live-in relationship in the nature of marriage and Domestic Violence Act says, in the nature of marriage, and Supreme Court says, what is the basic essential for a marriage? What is the essential of marriage? Basic necessity. You are all very good people, not thinking cunningly like me. Not having a spouse is the basic necessity. basic necessity is you should not have a spouse living, or if you had a spouse, you should have. So keeping this analogy, Supreme Court says for marriage the basic essential necessity is not having a spouse. If you have a spouse with you, you cannot marry. You have to go to jail. Extending that logic, Supreme Court says same logic is for live-in relationship in the nature of marriage. It says minus marriage, I am using the word, Supreme Court says for a live-in relationship minus marriage, they both should be like husband and wife. You understand, my dear?
Yes.
Minus marriage means now Chandru and Chandrika would not have went to a priest, not a church, not a temple. Minus that, both will be looked by the whole world as husband and wife. Suppose milk vendor comes, this lady should come out and say, please wait, sir is inside. She should not go and hide somewhere. If postman comes, she should not go and hide behind the doors. If that is there, it is not living relationship. It is something more than that. I do not know what is the meaning. Right? So commonly it is called as keep. You have that word here. K-E-E-P. He is keeping her safe, not showing her to the public. What will be, see, it is called as a safe, no? Keeping something in safe. Right? That relationships are not living relationships. This is one thing, please understand. So anybody, any one of us sitting in the hall, if you have an imagination that along with wife I can also have a living relationship, Domestic Violence Act says no. Right, my dear? Yes. Second, coming to women's side. Right? Understand this also. Chandru has got married to Chandrika. Right? I have told him my hometown is in Barrdc. I am living in Madras, which is 160 kilometers away. Right? Opposite to my house, there is one Rexona. Very beautiful than Chandrika. Now this Rexona is thinking, because now senior has introduced that Chandru is a bachelor. Like that somebody had told her that Chandru is like Sri Ram. Right? Yagapatini Viradan. Rexona believing this, without knowing, please understand all this difference. This is the basic difference in what a living relationship from the side of a woman. From the side of the woman, if she understands or deceived by Chandru that he is a Ekapatini Virdan or he has never married, he is like Lord Sri Rama, he has not even looked at any woman, she thinks that she is the first love for this bloody fellow. Right? If she thinks that Chandru is the man, right, like the protection, Chandru is the man, he is my man and all, she starts loving and living with Chandru, she is entitled for all the protections under the act. From her side, she believes that Chandru is not married. Okay, another example. Chandru and Chandrika got married, this Rexona was attending the marriage with Chandru. In all marriage photos, she is also standing. Right? After 6-7 months, the understanding between Rexona and Chandru has become more. After 5 years, she is going to court and filing a case telling that I lived with this man as husband and wife in a live-in relationship. If Chandru can show that photo stating that she is aware that I am a married man, in spite of that she has entered into my life, I also misused her, she is not entitled for anything. You understand, my dear?
Yes, sir.
You please don't confuse this thing. And in Hindu law, there is no multiple marriage, multiple living. No woman can come and say, I am the second wife, I am the third wife, I am the fourth wife. Wife is only one. Others you should not call as wife. Others you should not call as also a live-in relationship, because the moment you pronounce the word live-in relationship, it should follow with the word in the nature. Only this much. This is a simple thing, so don't get confused. Whenever you want to help a woman who is in a live-in relationship, you should tell stories that she is not aware of the previous marriage. If you are appearing for man, you should search for evidence that she is aware. What message she will put? How is your wife? Did you tell all this to your wife? Some message that she will put. Give it to the court. My lord, she is aware that I am already married. So to put it simply, there are two important facets or aspects in Domestic Violence Act. One is the woman as wife, another is live-in relationship. Okay? Suppose Chandru dies. Both will come for all reliefs. In that course also, the one who says she is in a live-in relationship should prove that, to my knowledge, I do not know that this fellow is married. You understand, my dear? Yes. Now we will go to some case laws. Should they be given some tea or something, sir?
It's coming.
We'll wait for tea or we'll proceed?
You can stop at that time.
If there is any bore also, I told you, you can raise your hands. It will not bore because Chandru is telling about some Chandrika, no, not about it.
The lady doesn't know the married of the
First wife.
In this IPC, he intentionally deceived to the there is the only difference.
Correct. Want anything? Why? Yes. Who is the most arrogant species? Mother-in-law, daughter-in-law. Daughter-in-laws will say mother-in-law. Soon you will become mother-in-law. You will say that these daughter-in-laws are very bad. Right? I will tell you one thing. See, I am repeating the same thing. This is a small life. Right? The more united you are, the more happy and powerful we are. We should not think that the whole lady should die very fast. Right? Bad thoughts will make you very sick and old soon. This whole life is like a small dream. Who knows about tomorrow? So don't fight. Don't advise people also to fight, and you also don't fight. The house should be very happy. Right? This is my prayer. Yes. Mother-in-laws, see, what section 4 and 5, all people who are going to appear in exams, APP exam, and otherwise also, section 4 and 5 of CRPC is akin to 4 and 5 of BNSS. Section 4 and 5 of CRPC is pari materia or is akin to section 4 and 5 of BNSS. What is section 4 and 5 of BNSS or CRPC? 4 and 5 of CRPC. Section 4 of CRPC says, whenever you want to read a special law like POCSO, juvenile justice, any special law, you should definitely read section 4 and 5. Section 4 and 5, 4 says, CRPC is the procedural law for IPC. Okay? Any offence under IPC, procedure is CRPC. This is section 4. Any offence under BNS, procedure is BNSS. This is section 4 of BNSS. Right? 5 says, if there is a special law, for example POCSO, procedures will be governed by the special law. And if the special law is deficit, in procedure, CRPC can aid. Or if special law says, no, your old general law, please get out, then special law will prevail. Example is, Chandru is getting married to Chandrika. Chandrika is a special law. Chandru's mother is Vijayalakshmi, CRPC. CRPC is powerful until which time? Yes. If a special law comes inside, 4 and 5 say, special law will prevail upon general law. You understand, my dear? Special laws are premium laws, like dosa. What dosa will prefer? Every day sada dosa, old mother-in-law. Suddenly this new lady will come, masala dosa. But masala will fade within 5 seconds. Right? Always know, whenever masala is boring, what dosa you will eat? Then you will go to amma. That is sada dosa. Right? Section 4 and 5 says, general laws, that is CRPC, procedural law is IPC. Special laws are governed by special procedure. Some houses, in some homes, mother-in-law and daughter-in-law will have a cordial relationship. That is section 5 says, if special law and CRPC are not inconsistent or consistent, then both can walk together. In some houses, rarely you will see mother-in-law and daughter-in-law will hold this thing hand and walk for a temple. Unless the other neighbors spoil them, they will walk together. Right? Like that, special laws are governed by special procedure. If special law does not oust by a ooster clause, some special law will say, I prevail over CRPC or CRPC is not applicable. So whenever you take any law, you should go and peruse that law and understand whether special law is applicable exclusively or whether the special law says I am ousting out the general law CRPC. All this you should say. Okay. Question is, mother-in-law, can a mother-in-law file a case as against a daughter-in-law? Yes. I appeared in a case, I will give that, I appeared in a case before the Honorable Madras High Court. The facts are like that. My senior's office in Pondicherry, they filed a case, that is mother-in-law filed a case as against daughter-in-law. This mother-in-law lady has got two daughter-in-laws, elder daughter-in-law and younger daughter-in-law. This younger daughter-in-law and mother-in-law joined together for filing a case as against the first daughter-in-law. What has happened, what is the difficulty is, the son became sick. Some syndrome, some autoimmune syndrome. 90% they become disabled in a wheelchair. Now the daughter-in-law will come, she will give one slap to the mother-in-law, take some money. You have married this fellow to me. After marriage, after 15 years only this man became sick. Every time she comes, tortures, slap the mother-in-law, old, she is 80 years old. Then this mother-in-law went to a CJM court in Pondicherry, Chief Judicial Magistrate Court, filed a Section 12 application. That magistrate returned it stating that Domestic Violence Act is applicable only for newly married women in the house. This man, CJM, was not given a class like this by the bar. Where from he has learned? I told you, no, reading the topic itself you will understand. Protection of women. In that all women will come. This beautiful man, a good judge, had said, no, Domestic Violence Act is applicable for newly wedded wives, that too, not old wives. This case, on question of maintainability, we took it to High Court. High Court I appeared, the judge has written that you can also read and enjoy. See, now, real victimization is by daughter-in-law to mother-in-law. Which is secondary victimization? Coming to court, magistrate is telling, no, you should receive beatings. Domestic violence will not protect you. This is secondary victimization. Then she has to spend before the CJM court, she should spend for me before the High Court. All these are secondary victimization. If courts are ignorant, if advocates are ignorant, then the fate of citizens will be like this. Okay. You want some rest to this thing?
See, you can spend 5 minutes.
15 minutes or 5 minutes?
5 minutes.
Whether in 5 minutes you will TV Manjula Bai versus TS Suvarna, SUVARNA. TV Manjula Bai versus T.S. Suvarna. 31/7/2024. 31/7/2024, Madras High Court. Okay.
It's a small doubt.
Yes, ma'am.
Section 12 is saying purely that was the application not as a complaint. But in some court they are filing.
Please give the mic.
Purely application, not a complaint.
Correct.
But as a respondent, we are filing the 317 petition and access.
Should not file.
But
Should not.
Should not. But in some officers are insisting.
You teach him tomorrow. You teach him. No. What she is asking is right. That is the reason I said this is the duty of the bar to enlighten the magistrate, to show him. I will specifically answer her first. Okay. I have told you this judgment. Second judgment is Bombay judgment. Mother-in-law can file a case as against daughter-in-law. Bombay judgment is Mrs. Zeba, Z-E-B-A, Mrs. Zeba, Z-E-B-A, Mrs. Zeba Mohasin Patan, M-O-H-A-S-I-N, Mrs. Mohasin Patan, P-A-T-H-A-N, Patan and another versus state of Maharashtra. 5/1/2024. I am repeating, Mrs. Zeba or Ziba, ZTBA MOHASIN Patan, and another as a state of Maharashtra, dated 5/1/2024, Bombay High Court. These two judgments are for the proposition that mother-in-law can file a case as against daughter-in-law. Okay, now we will come to the question. What is your name, my dear?
Nalini.
Lalit.
Nalini.
Nalini. Okay. We will come to the first principles. Do you have the book, Domestic Violence? Yes, you all should have the book. Firstly, I have told you why a 317 petition should not be filed this. He is not a accused. It is not a criminal complaint. Okay. Then section 2A says, section 2 small a of domestic violence says, she is an aggrieved person. This is point 1. 2Q says, he is a respondent, not a accused. Section 3 says, it is a abuse. It is not a crime. Teach that magistrate who is asking for that. I think
They were not taught.
yes, he does not want to understand also. Okay. Then now please come to section 13. Section 13 of DV Act. Section 13 of DV Act speaks of service of notice. It doesn't say it is service of warrant or summons under Criminal Procedure Code. Service of notice. Section 13 of Domestic Violence Act should be read with Rule 12 of Domestic Violence Rules. Service of how it should be served, who should serve, protection officer should serve. 13 of DV Act should be read with 12 of DV Rules. Yes, my dear? Yes. Then please come to Form 7. Take Form 7. Form 7 says, you have Form 7? It says, notice for appearance under Section 13(1) of Protection of Women from Domestic Violence Act. Now, whereas the petitioner has filed an yes, you tell your magistrate that it is not a complaint, it is an application. Down the line, you are hereby authorized to appear before this court in the noon or day personally or through a authorized counsel. In a civil case, in a wakalat only, it will be like this. In a criminal case, in a summons or a warrant, it will say, you are either hereby required or ordered to appear in person. So when the legislature mandate says that section 2Q says he is a respondent, 12 says it is an application by an aggrieved person, 13 says it is service of notice, Form 7 says it is notice, either you or your duly, this thing means, I will tell you lot of judgments, the only way out of for a magistrate for non-appearance is ex parte, that's all. It is not a criminal case, no warrant can be issued until the stage of section 28. I am using the word until section 28, there is no question of warrant. I told you we will come to section 31 and 32 later point of time. I am telling that this fellow is a respondent. She is an aggrieved person. It is not for a crime. It is for a civil law. Stopping for a moment, please come to the statement and object of the act. Come to para 2, 4th line, 3rd line, para 2, 3rd line. What does it say? The civil law does not address, however, address the phenomenon in its entirety. It says there is no adequate remedy under the civil law for women. So, in order to give addition to the civil law remedy, DV has come. You understand, my dear, all this? Yes. In spite of this, if some magistrate is telling, you tell the magistrate, you pass an order that a 317 has to be filed, take it to the appellate court and take it to the high court I will also tell you that the magistrates, or I will give you citations, you give it to them. Okay, they should be taught. Right, my dear? Yes. All question and answer will deal at the end of the session. I will just tell you, now the proposition is mother-in-law can file a case as against the daughter-in-law. This is the first thing. Okay. Now we will come to, yes. Who can be an aggrieved person under DV? We have already discussed. Who can be an aggrieved person? Excellent. Any woman. Okay, answer is Prabha Tyagi versus Kamalesh. Prabha Tyagi, Tyagi, Prabha Tyagi versus Kamalesh Devi. 12/5/2022 Supreme Court. Prabha Tyagi versus Kamalesh Devi. Supreme Court, 12/5/2022. Any woman can be an aggrieved person. That's all. To 12/5/2022. Okay. Jot it very fast, very keen, because as Secretary Sir said, time is very, very short. Okay. If I am going to repeat, then it will not. Establishing for maintaining a complaint under Section 12, whether a legal marriage is required.
No, sir.
Two category of women can come. One as a wife, another. Yes. You should not leave the tail. Tail is very important. Two category of women can come to the court apart from grandmother, mother, sister, and all this. Two category of women can file it. Okay? Yes. Whether Domestic Violence Act is applicable to any woman in the country?
Yes, sir.
Christian, Muslim, Parsi, social, economic, this thing, any woman. Yes, Vijay Kumari, Vijay, not Vijay, Vijay, yes, Vijay Kumari versus Maunveshwarachari, Maun, M-O-W-N, Maun Vesh, W-E-S-H, Maunveshwarachari, W-A-R-A-C-H-A-R-I. It is yes, Vijay Kumari versus Maunveshwarachari, 10/9/2024. Supreme Court says DV is a civil code. DV is a piece of civil code. Underline the word piece of civil code, which is applicable to every woman irrespective of any religion. DV, you should underline two things. It is a civil code applicable to any woman irrespective of any religion. All these words are very important. Okay. It is an effective measure guaranteed by the Constitution of India. What is the provision, my dear? 15(3). Right? Yes. I think you all will become experts very soon. Telangana Bar, Rangareddy Bar is going to be an expert in DV law. Okay. Yes. Yes. If you take Section 12, now you can take the book for a moment. If you take Section 12 subsection 1 says, if you want to read any section, if you want to understand a section, before reading the section, you should read the marginal notes. What is marginal notes? Caption. Before reading the marginal note, you should see in which chapter it is. I have told you, before going into the hotel, you need not go to the kitchen and open every box. You should first read the board. Now it is menu card. Or you should first see whether it is a vegetarian hotel or a non-vegetarian, or both mixed. Right? Now chapter 4 says procedure for obtaining orders for relief. Procedure for obtaining orders of relief. Section 12 says application to magistrate. Subsection 1 says an aggrieved person or a protection officer or any other person on behalf of an aggrieved person may present an application. So 3 persons can file. Who are they? Either Chandrika or protection officer of that area or Chandrika's children or any other person. You understand, my dear? So, like that, the criminal law, like this, a criminal law can be set into motion by whom?
Any person.
Excellent. Who said this? Give a big clap. What is your name?
Manjuna.
Manjuna. This is not a big clap. This is not even sufficient to beat a mosquito. See, you should be generous in appreciating yourself. If you argue nicely, no judge is going to clap in the court. Right? If a judge writes a beautiful judgment, nobody is going to clap. This is an opportunity for us to appreciate ourselves. Law minister will not come and appreciate. Right? This is an opportunity. See, a criminal law can be set into motion by any person. This is the beautiful answer. See, suppose Srinath sir beats Chandru now. Whether Chandru is a witness or a victim? Victim. Both witness and both victim. A girl is raped in a paddy field where nobody is there. Who is the victim? The girl. She is the victim, she is the witness. Why? A witness is a person who has perceived it through her senses. Who is a witness? A witness is a person who has perceived an event through any one of his senses. This is a girl who has perceived that fellow by the eyes, by the bodily actions, by the pain, everything. So, victim will always be the primary witness. Victim is the primary witness of any crime. This is point 1. Other witnesses may either would have seen or heard or by tactual sense have felt it. Okay, this is another part of the story. Now, a victim is also a witness. A criminal law is set into motion by if Srinath sir beats Chandru, either Chandru can go to the police station or senior can go to the police station, or now what happens, Nalini is calling my old mother in Pondicherry and telling Srinath sir has beaten Chandru. My mother has not seen this. Sir has seen this. Chandru is both victim and witness. I can set the law into motion. Point 1. Witness he has seen, he has gone to the police station. Nalini is informing my mother. My mother is 1,000 kilometers away. She is a hearsay witness. She can set the law into motion. She will say, I heard through Nalini that my son was beaten. You understand, my dear? As Manjunath has said, criminal law can be set into motion by anybody. Like that section 12 says, either the aggrieved person or the protection officer or anybody on behalf of the aggrieved person can set the law into motion. Come to the proviso. Proviso says, provided that before passing, see, these provisos are very dangerous. Main section will say something. Today evening I am going to a park. I do not know where is the park. All these are imaginary stories to keep you alive. Today evening I am going with one ex to a park. We are going to talk for 3 hours on future marriage. She is just asking me an ice cream. I am giving her an ice cream, some chicken, everything. After 9 o'clock she is telling, I am asking her, will you marry tomorrow? Yes, we will marry, but provided my brother should say yes. So all these 3-hour talks of this thing will be axed down by this proviso. In law, this proviso is very dangerous. If something says provided, you should think that proviso is going to say something ulta. Right, like that it says, first proviso says, you can set the law into motion. Second proviso says, provided that before passing any order on such application, magistrate shall take into consideration any domestic incident report received by him from the protection officer or the service provider. So it gives an appearance as if the magistrate is powerless without a domestic incident report. This domestic incident report is given by a protection officer. Protection officer is like our policeman. If a crime is reported, the policeman will come, examine some 2 or 3 persons. He will not examine, he will sit in the table and he will ask witnesses' name and give. Like that, our protection officer also will do all these protection works. Okay? Now, the word shall is there, provided is there. It was thought whether this is mandatory. Law says all may or not may, all shall or not shall. You understand, my dear?
Yes.
Sometimes shall will become may. Sometimes may will become shall. I will give you one judgment. You read that CBI versus Master Bolu. CBI versus Master Bolu. BHOLU. It is a 2020 or 21 judgment, right? Regarding interpretation of section 14 of juvenile justice. We will see in detail that. In that, the word may, in that what is said is, section 14 of juvenile justice speaks for a preliminary assessment. It says the board may use a psychologist for assessment. Supreme Court says this may should be read as shall. If there is no psychologist for assessment, then it is an empty exercise. Right? Now coming to section 148 of CPC. What is section 140 of CPC? Enlarging of time. Whenever any civil suit is filed, we will not file the return statement in time. Right? I became advocate in 1997. After 2002 only all civil suits are seeing the light very fast. For return statement itself, there are bundles for 10 years. Each adjournments will be for 4 months or 5 months. 2 adjournments or 3 adjournments, 1 year is gone. So if a judge gives 10 adjournments, 5 years gone. After 2002, amendment came that return statement shall be filed within 90 days. It says shall. But we people from Tamil Nadu, we challenged CPC. We are challenging BNSS also. We will challenge all laws. We are very sharp. Right? Because we always weigh the old laws in higher esteem. We respect mothers and mother-in-laws much. Right? We do not want any general law to get out of the society. If any new thing comes, immediately Tamil Nadu will challenge it. Now also Tamil Nadu is challenging BNSS. Writ petitions are pending. We went on strike also. New BNSS, BNS and BSA. Right? Like that CPC we challenged. We went to the Supreme Court. That is called the Salem Bar Association. Salem Bar Association versus Union of India, 2002 judgment. See, in that Supreme Court said, the word shall should be read as may. Reasons are, and this is for civil law. Coming to criminal law, Lalita Kumari versus Union of India, 2014, I think, 13. Lalita Kumari versus Government of UP. Lalita Kumari versus Government of UP, 2013 Supreme Court, regarding the word shall in section 154 CRPC. Section 154 CRPC says, every information given to a police station, if it reveals a cognizable offence, shall be reduced into writing. You understand? See, now why I am telling all this, how a word shall should be understood. Whether the word shall is mandatory or discretionary should be understood in the context of each law. To put it simply, CPC says, Salem Bar Association says, the word shall is used, but penal consequence is not there. Right? Legislature has not said, suppose it is not filed, what will happen? It has not been said. So Supreme Court has interpreted in Salem Bar Association, favoring advocates, that the word shall should not be read as shall, it should be read as may. Coming to Master Bolu's case, Supreme Court said may should be read as shall because it involves a life of a child. Public policy should be seen while interpreting may or shall. In Lalita Kumari, Supreme Court said, if FIR is not registered based on an information, then public policy will get affected, people will suffer, police people will become like kings. And in a criminal law, IPC says, section 166 and 166A of IPC speaks of disobedience of law. So if CRPC is disobeyed, it is a punishable offence under IPC 166. Understand, my dear? Old Lalita Kumari is 154 CRPC, the word shall is used. If this shall, if it is not obeyed, disobedience of CRPC is punishable under IPC 166 and 166A. So the constitutional bench in Lalita Kumari as government of UP said, it is mandatory. If policeman doesn't, on receipt of information which reveals a cognizable offence, if policeman doesn't register an FIR, then it is a contempt of Supreme Court or the High Courts. Right? Reading all this, what is the clue we are getting is, word shall is not always shall. Now coming to DVC, if this shall is taken as a shall mandatory, I have told you in the previous session, section 23 speaks for what reliefs? Speedy interim reliefs. Right? Section 12 will say first hearing date should not exceed 3 days. In the DVC, if an application is given to a sensible magistrate, underline the word sensible magistrate. If an application is given to a sensible magistrate, section 12 says, read with section 13 of the Act and 12 of the rules, section 12, section 13 of the Act, read with rule 12, all this conjointly says, on the presentation, the first hearing date shall not exceed 3 days. That is, notice should be served through the protection officer within 2 days. So, on presentation, the man who is sitting as a magistrate should number it on the same day. No dramas are invited. What is the drama? Return, representation. See, all these dramas are made because it is some other man's problem. We think the problem is not our problem, right? A person comes to court with great hope and belief that this fellow is a god, he is going to guard me. If a magistrate thinks it is a business, it is a work for him, then this is very pathetic, right? If courts are insensitive, then they are not respecting the oath that they have taken, then the constitution will be put to shame. Then there is no meaning in celebrating all these constitutions, right? There is a saying, idols in temple, idols no in temple, you go and pray. Those idols are called perpetual minors. What is the meaning? Perpetual minors. That is, they have to be taken care by the priest, they have to be taken care by the trustees, by all of us. Even if the age of the god is 2000 years old temple, that god's age is minor. Perpetual minor. The property of the temple should be taken care. It should not be taken home. It should be taken care. Some trustees know they are thinking property should be taken home. It should be taken care. Every god and every idol is a perpetual minor. Like that, our constitution is also a perpetual minor. It should be given care by the courts, by the authorities. Otherwise, the constitution is like some other book, that's all. There is no meaning like that. In section 12, subsection 1 proviso says, what does it say? Provided that no order shall be passed before receiving a domestic incidents report. Now we saw in section 23 that she is entitled for speedy interim ex parte relief. If the protection officer's incidents report is mandatory, if it has to be seen like that, this protection officer will come after a year and give the report. Right? Now law has interpreted this shall and says this shall is not shall. It is may. You understand, my dear? So each word is pregnant in law. From the beginning I am telling you should develop a different sight in looking at it. Each word is pregnant. What do I mean by the word pregnant?
It can be interpreted.
It will deliver a lot of meanings. See, if my mother is pregnant, nobody knows whether one Chandru will come or so many Chandrus will come. It all depends upon the thing inside. Like that, each word is pregnant. See, one word in Lalita Kumari, FIR, every information. This one word has given rise to a constitutional bench judgment. CRPC is of the year 1861. Lalita Kumari is of the year 2013. So that pregnancy is required for how many years to deliver what is the meaning of that? 1861 CRPC. Then it was amended in the year 1898. 1861, 1898, then a major amendment in 1973, then 2001, 2005, 2009, 13, 18, lot of these things. See, why I am using the word pregnant is, it depends upon the judge's intelligence. See, in all judgments, the judge will say, having stood over for consideration until this date. Every judgment is called as a delivery. This court delivered the judgment. Father, plaint. Mother is written statement. Framing of issues is fusion, zygote. Every judgment says, having stood over for consideration all these days, I am delivering the following judgments. If this sperm and ovum, like both the defense counsel and prosecution is weak, the children which is coming out will be aborted child. If you say that these judgments are very weak, we are not strong. The prosecutor and the defense should be so strong, then only the judgments will be strong. You understand, my dear? Yes. So that is, the credit should go to the society, your society and the bar association, like judgment should be given, training should be given, such that the bar becomes strong. From the bar only prosecution comes. From the bar only you write exams and come out. So it is the major duty of the association, bar association, to do things like that, to call for research people. I have told today morning our home GP, Sir Mahesh, right? In Pondicherry, when my senior was a bar association vice president, she was conducting weekly classes. All Friday evenings, 2 hours. Some senior will come and entertain. Like that, if we do like that, then it will be really of great use. Now this word in section 12, shall, is not. So that will not, the word shall will not tie the hands of a magistrate in giving relief. That is, the moment you file an application, he should number it on the same day. If an interim order is required, he should pass it on the same day. Right? If he is not going to pass an order of residence, the girl says, I want a residence order. I am with a child or I am alone. There is a duty on the magistrate. You please come to section 4 and 5. Section 5. Duties of police officer, service provider and magistrates. Whether any one of you sitting here had shown the magistrate section 5 and asked him, if you are not going to give a residence, give her a shelter. Every magistrate who is sitting as a judicial magistrate for domestic violence should have a big list with him. What is the list? For shelter home, for protection, for medical aid, everything. Whether they are doing it here? No. Law will come to life only if you tell him, see, there is a provision. Please look into that. You can take some time to provide a residence in the husband's house. Till then,
stay homes.
Where she will be? Either she should commit suicide, somebody will rape her, or she should die. Law doesn't warrant her to be in a platform. Law warrants that she should be in the shelter home. It is the duty of the police officer, service providers and magistrates. Okay? Yes. Now, you can write some judgments regarding whether domestic incidents report, question, whether domestic incidents report is mandatory or discretionary. Answer is Whether domestic incident report is mandatory or discretionary? Discretionary. Yes. Dr. M. Patchirajan. Dr. M. Patchirajan. Patchi. Patchirajan versus the protection officer. 13/12/2012. Then Prabha Tyagi versus Kamalesh Devi. We have already seen the judgment. In that judgment also the Supreme Court has discussed. Prabha Tyagi versus Kamalesh Devi, 12/5/2022. Okay. Come to a very important point. For an interim relief, section 2A says, please come to 2A. For an interim relief, no proof is required. When proof will come? After C. For obtaining a relief under DVC, no proof is required. Prima facie evidence is required. What is the difference, my dear, between prima facie and proof? See, you suppose, I am filing a suit for an injunction. In that I am asking for an interim injunction. What is the difference between seeking for interim relief and seeking for the main relief? In interim relief, what you will tell the court? I am making out a prima facie case. Right? What Chandru will, in a suit for injunction, there is an interim injunction application. I will say, see, this is the voter card, this is the ration card, this is the electricity, this thing, this is gas bill, this is phone, this thing. So I have made out a case that I am residing there. Unless the other person comes and say, no, all this is forged, I have made out a prima facie case for an interim relief. Like that, making out of a prima facie case is sufficient for obtaining interim relief, because section 2A says an aggrieved person alleges. The word used is 2A says aggrieved person means any woman who is or has been in a relationship with the respondent and who alleges to have been subjected, right? Who proves to have been subjected. No. For the final relief under section 12, at the end of the trial, she should prove. Under section 12, at the end of the trial, she should prove everything. For an interim relief, she need not prove, but she should allege prima facie, there should be prima facie materials. Okay? Then come to 2A once again. Aggrieved person means any woman who is or has been. Right? Act has come into effect in 2005. Right? Chandrika got married in 1997. Whether she can come to court now and say, I got married with Chandru in 1997, I am filing an application for domestic violence. He subjected me to cruelty in 2002, 2002, 3, 4. Can a woman come tomorrow to the court, 2025, can she come and say to the court that 2002, 2003, 2004, this fool has harassed me, put me under? I told you a catchy word. Weeps. Can she come?
Yes, sir.
Yes. Is there limitation in the domestic violence, sir?
No, sir.
Why, my dear? Why means the act does not speak about any limitation. And the word used is in 2A, is or has been in the past or in the present. Okay, so Domestic Violence Act does not contain any limitation for initiation. I am not talking about 31 and 32. 31 and 32 of DV Act will prescribe for limitation, right? And for that too also, if you read section 468 to 473, anybody has got CRPC with you? CRPC. You will have in the phone, no? Take 468.
6 months, 3 years.
Yes. What senior is telling? 468 to 473. 468 to 472 speaks of limitation beautifully. I am using the word 468 to 472 speaks of limitation. 473 is like the arrogant daughter-in-law. right? Read 473 now. You all know that for every offence there is limitation. If it is barred under limitation, court will not take cognizance, right? Come to 473. Somebody read, please. Mic. Give the mic. Somebody read 473.
Notwithstanding anything contained in the
Give the mic
following
to Nalini.
provision.
Nalini, please wait.
Notwithstanding anything.
You should read that word. Now you should read section 473 of CRPC. Then you should read notwithstanding. No, notwithstanding means you should imagine that you are an arrogant daughter-in-law for a moment. Notwithstanding means this new entrant will come and say, from today I am the queen. Whatever you are until yesterday, notwithstanding anything that you have done in the home, I will do that. See, 468 to 472 speaks of lot of things. If it is punishable for 6 months, for fine, for 3 years. 473 says, notwithstanding anything in the preceding sections. Yes, my dear, read it.
Foregoing provisions of this chapter.
No, you should read it more effectively.
From the section 473, extension of period of limitation in certain cases. Notwithstanding anything contained in the foregoing provisions of this chapter.
Stop it for a moment. That means what? You should, for a moment, forget 468 to 472. Notwithstanding anything contained
in the foregoing provision of this chapter.
Full, it has erased everything. Right? Yes.
Any court may take cognizance of an offence after the expiry of the period of limitation.
Any court may take cognizance of an offence after the period of limitation.
If it is satisfied on the facts and in the circumstances of the cases that the delay has been properly explained.
1 second. If the court, who will explain to the court? The excellent public prosecutor or the complainant will say, right? Because of this, there is a delay. If a public prosecutor like me, a fool is not explained. See the last dangerous word, or
that it is necessary so to do in the interest of justice.
A public prosecutor need not explain. Or is a conjunction in law. Brothers, please, very carefully see. And is conjunction, and is connecting, or is disjunction. Once again, like may and shall, all and is not always under, all or is not always or. Some or should be read as, no, I have not stopped you. Once again, please read detail. Totally. Now listen. I will put it very succinctly. Okay. See, with regard to limitation, we all generally believe, because we are all defense counsel, we think 468 to 472 should be celebrated. If a judge is very sensible, even if the public prosecutor is very lazy and sleepy, judge can say, in the interest of justice, I will take it on fine. Understand, my dear? 473, tail is very strong. Tail contains the sting. It is said in English that the tail will always contain the sting. But we are all very lethargic. No judge wants to read 473 tail, and we will be very happy if the judge throws the case on the point of limitation, because victim is in the home crying. In any case, there is a victim who sits in the home and cries for remedy. DVC, thank you, my dear. DVC is an act where there is no limitation prescribed. So, a domestic violence act initiation can be given for the present violence or for the past violence. But coming to section 31 and 32, it says a period of within a period of 1 year from the date of disobedience of order. Right? If somebody, now you are all aware of section 473 tail. if somebody raises the plea of limitation, you should say these laws are designed for
Applicable.
Designed for what? Social welfare legislation. In the interest of justice, a crippled woman's relief should not be thrown out for the purposes of limitation. This should be your argument whenever anybody raises the plea of limitation. You should say, even if it is properly explained, not explained, if court thinks limitation can be waived, court should not give all the beautiful explanations for 468 to 472 that this lady itself is a poor lady. She is in a matrimony. You cannot just fire that lady because you have not come within 1 year of disobedience of the law. So 473 is very, very important. Okay? Yes. So there is no limitation. Right? It is all very clear.
Yes.
So, I will tell you 2 judgments where to obtain a final relief, proof is necessary. To obtain a relief under Domestic Violence Act, proof of domestic violence is essential at the end. Right? Right, 2 judgments. Manmohan Attavar versus Neelam Manmohan Attavar, A-T-T-A-V-A-R, Manmohan Attavar versus Neelam Manmohan Attavar. Manmohan Attavar versus Neelam Manmohan Attavar, 14/7/2017, Supreme Court judgment. Then Sangeeta, S-A-N-G-A-T-A, Sangeeta Saha, S-A-H-A, Sangeeta Saha versus Abhijit Saha, A-B-H-I-J-I-T, Sangeeta Saha versus Abhijit Saha, 28/1/2019, Supreme Court. Mohan Attavar versus Neelam Manmohan Attavar, Sangeeta Saha versus Abhijit Saha, 2019. Both judgment says to obtain a relief under Domestic Violence Act, proof is essential. At the fag end, without the proof, what are the things that has to be proved is, firstly, that there is a domestic relationship. For what proof is essential? There is a domestic relationship. Then there is a domestic violence. You understand, my dear? 2 things have to be proved in the case. One is domestic relationship, second is domestic violence. Okay? Yes. Then, can a husband be thrown out of the house belonging to him? Obviously you will say no, they will say yes.
Yes.
Question is, the husband has earned, it is his self-acquired property, right? After marriage, that house has become the shared household of the wife. Question is, wife comes to the court and says, this fool is beating me every day, is kicking me in the stomach, spitting me on the face, not giving me any food, and all these constitute whips. Now she is telling, his very presence is dangerous for me, throw him out. She files an application under 19th Residential Law. Right? She also adds the mother-in-law and she says both have to be removed. Now you should answer for the first question, whether an husband who owns the property can be thrown out of his property. No. Yes or no? Yes. No, yes. 2 answers are possible. Yes. Answer is yes. Yes. Samir Vidyasagar Bharadwaj. Samir, S-A-M-I-R. Samir Vidyasagar Bharadwaj. B-H-A-R-A-D-W-A-G. Samir Vidyasagar Bharadwaj versus Nandita Samir Bharadwaj. 16/1/2018 Supreme Court. Samir Vidyasagar Bharadwaj versus Nandita Samir Bharadwaj. 16/1/2018 Supreme Court. Husband owning the property can be removed until the disposal of the case if the court feels that the aggrieved person's life and limb will be in danger. Okay, you are all happy? Yes. Who has told him to marry first of all? Now please, second question, right? Along with the husband, the daughter-in-law as an agreed person has now added mother also to be thrown out of the house, right? Please come to 19 subsection 1 F proviso. 19 subsection 1 F proviso. Provided that no order under class B shall be passed against any person who is a woman. What is class B? Removing, directing the respondent to remove himself from the shared house. I said if it is a man, if the woman says he has to be removed from the house, he can be removed under 19(1)(b). You can remove an husband or any man from the house under 19 subsection 1 subclass B. But such a removal order in DVC cannot be given as against a woman. Please note it, that is the one difference. Domestic Violence Act says you can add a woman as a respondent, but court will say you don't disturb. Restraint order can be passed, but a removal order cannot be passed. Okay, 19(1) subsection F proviso says a removal order against woman cannot be passed. This is the one important thing, my dear. Okay. If your examiner is very intelligent, he will ask all these questions. If you are very intelligent than him, you can take the exams very nicely. Okay. This Chandrika and Chandru are in a rental house. Right? The landlord is our Srinath sir. Chandrika goes and says, this is my matrimonial home. Chandru married me in 2024, took me in this house. It is a bungalow type house because Srinath sir is very wealthy. And now Chandru has escaped. From Madras he is telling I am in Telangana. She is filing a petition that Chandru should be restrained. She is asking for a protection that she should not be evicted. What she will go and say? I, aggrieved person, Chandrika, married this fool and this year, he has escaped. Now he is instructing the landlord to throw me out, pass an injunction order. Court will pass an injunction order as against Chandru that you should not remove, you pay the rent. Sir goes, now Srinath sir goes to a civil court to evict me and that fellow. Can a landlord evict the aggrieved person through due process of law?
Yes, sir. Yes.
A landlord's right is always protected, my dear. You understand? A right of a woman in a shared household, section 17, right of a woman in a shared household can be exercised in any property. Husband need not be the owner of the property. Understand, my dear? Shared household means it need not be the owned property of the husband. Whenever the wife comes inside, she will be shown certain property that this is the place of your matrimonial abode. That place becomes the shared household. That shared household need not be the property owned by the husband. However, landlord's right is also protected. Okay? You can write this, landlord's right is also protected. Write this judgment, Archana, A-R-C-H-A-N-A, Archana, Goindi, G-O-I-N-D-A, Goindi, Archana Goindi, Kandelwal, K-H-A-N-D-E-L-W-A-L, Archana Goindi Kandelwal versus Rajesh Bal Krishnan, B-A-L, Krishnan Menon. Archana Goindi Kandelwal versus Rajesh Bal Krishnan Menon, 4/3/2022, Supreme Court. In a dispute between husband and wife in DVC, landlord should not suffer. He has an option of eviction. Understand? Yes. Next. In a dispute between Chandrika and Chandru, along with Chandru, she is adding Chandru's wife and, Chandru's mother and father. Respondent 2 and 3. then Chandru's sisters, sister's husbands, right? Then Chandru's sister's husband's servants, Chandru's car driver, then the persons in the front of the house, rental people, right? She has arrayed some 20 to 30 people as respondents. Now, when a case is filed under DVC, whether the magistrate is duty bound to issue notice, form 7 notice to all the respondents, or the magistrate can pass a restricted order of summons. Magistrate, while passing an order, should take note of whether there are allegations as against respondents, and respondents should have what? Domestic relationship. She cannot add my car driver, my peon, my clerk, my steno. Understand, my dear? So, court says that you should not pass an order of summoning everybody. Okay? In the domestic violence proceedings, the magistrate should pass an order of issuing notice to the respondents only if there is a subsisting domestic relationship, not to everybody. Take the judgment, it is in Vijay Bhaskar versus Suganya Devi. Beautiful judgment, old judgment. Vijay Bhaskar versus Suganya Devi. 28/10/2010 Madras High Court. Vijay Bhaskar versus Suganya Devi. Then, same proposition, Ashish Dikshit. ASHISH. Ashish Dikshit. DIXIT. Ashish Dikshit versus State of UP. 7/1/2013 Supreme Court. Ashish Dikshit versus State of UP. 7/1/2013. It says DVC is a civil law. Point 1. It says you should not issue summons in a haphazard way. Then it asks a question whether concept of bail is available in Ashish Dikshit is very important point. Whether bail is available in DVC. Why, my dear? It's a crime, not a crime. Excellent. Why this group is active and you are all very silent? Whether they are threatening you or you are giving respect to them. You are all not writing exams. Or you are all respecting women, and whenever woman talks, you don't talk. See, in Telangana I am seeing so many good factors. When women are talking, men are not talking. Giving more respect.
Avoiding domestic violence.
Avoiding domestic violence. Super, sir. So, please jot down, in Ashish Dikshit, the Supreme Court has said, there is no concept of bail in DVC, no anticipatory bail or bail, because it is not a criminal procedure, it is a civil procedure. Okay? Yes. Is there we were discussing, is there a concept of framing of charge or discharge? 2 judgments. These 2 judgments are beautiful judgments. Please have it with you. Okay, Padmanabhan, P. Padmanathan, P for Pondicherry. P. Padmanathan, PATHMANATHAN, P. Padmanathan versus V. Monica. P. Padmanathan versus V. Monica. This is a judgment of 18/1/2021 Madras High Court. Right? P. Padmanathan versus V. Monica, 18/1/2021, followed by, this is single judge. Full bench. What is a full bench, my dear? How many judges?
5.
Single bench. Why it is set as a division bench? They can divide, but they will never divide, because one senior most judge will sit, one junior most judge will sit. He will say, yes, my lord, yes. It will never divide. So it is an undivided bench. It should not be called as division bench. It should be called as UDB. It will never, it is an undivided bench. So senior will look at the junior judge, he will just not open his mouth. The thing is, both should divide in their opinion, both should discuss, arrive at a common sense, right? Common consensus. Now, full bench is 3 judges, FB. right? If it is more than full 3 judges, it should not be called as a constitutional bench in High Court, because constitutional bench are only in the Supreme Court. Here it should be called as a larger bench. 3 judges or full bench. Beyond that, it is a special bench or larger bench constituted for a specific purpose in the High Court. So, single bench, division bench, full bench, larger bench or special bench. In Supreme Court of India, Article 146 says there shall be a minimum of 5 judges. Article 146, there shall be a minimum of 5 judges for deciding a question on law, on an interpretation of constitution. Okay, those are called as wise men. VWISC, wise men. Okay. Suppose during trainings in court, no, trainee magistrate and a district judge will be sitting. What is that bench? You have not seen here. During training, no 2 or 3 judges will be sitting. What bench?
Special bench.
No special bench.
Training.
No trainee bench. It is just a bench. That's all. Coming to this Padmanabhan, and another judgment is Arun Daniel, full bench. Arun Daniel versus Arun Daniel, DANIEL. Arun Daniel and others versus Suganya. 17/11/2022, full bench, Madras High Court. 17/11/2022. See, reading this Monica and Arun Daniel, Madras High Court says, citing Supreme Court judgment, Madras High Court says, a magistrate need not issue notice to all the respondents. Point 1. So, you should be very careful in drafting. If you are adding 5 respondents, you should see to that you should make allegations as against all the 5, because all 5 should not live in peace. They should not escape the summons. So from today you should say, while drafting, respondent 1 allegations are this, respondent 2 allegations are this, such that if I train the magistrate tomorrow, I will tell him if there is no allegations as against some respondent, you should not issue notice. So in order to overcome that, you should draft it in a special way. As against respondent 1, these are the allegations. So Padmanabhan says, Arun Daniel and Padmanabhan says, magistrate need not mechanically issue notice to all the respondents. Respondents as against whom allegations are there alone should be issued notice. That after receiving that notice, respondent need not go to appellate court under 29 or need not go to high court under 226. He should come and agitate it before the same magistrate. Which section, my dear? We were discussing 18, 19, 20, 21, 22, 23. Appeal is 29. I told you he need not respondent against whom no allegation is there. Notice was issued. Where he can come? Same magistrate he can come. Because in a criminal case only there is no recall, there is no review. We have told it is not a criminal case. And I told you one provision regarding ex parte. 20? There is no ex parte in this. No setting aside ex parte in DVC. I told you one provision. Revoking 25. What are the 3 things? Now, this man should come and say, see, reading the allegations in the DVC, I am a respondent 7 or 8. Nothing has been said as against you. Why I should be in the trial for such a long time? Now you recall the order. You understand, my dear? You revoke the order as against me because this order was made without application of mechanically. So read this Arun Daniel, beautiful judgment. Read this, it says no discharge. Arun Daniel full bench says because there is no framing of charge, no discharge. Right? So many concepts are dealt in Arun Daniel's case. Read that also. I will ask you another question. can a criminal complaint amendment is possible? In a criminal complaint, now we are not talking about DVC. Okay, before that I am asking another question. In the DVC, can amendment be made? What is the provision for amendment in CPC? Order 6? Yes. In DVC, amendment is possible. Question is whether DVC amendment is possible? Yes. Write the judgment Punnappa Reddy. Punnappa Reddy. I think it is your state's name.
Yes.
So you happily write. Punnappa Reddy alias Nukala Shanka Balaji. Punnappa Reddy alias Nukala Shanka Balaji versus Punnappa Reddy Swarna Kumari. Punnappa Reddy alias Nukala Shanka Balaji versus Punnappa Reddy Swarna Kumari and another 18/4/2016 Supreme Court. Complaint under 18/4/2016 Supreme Court. It says a complaint under DVC amendment can be sought for and amendment can be made. Yes, my dear?
It was application, it wasn't a complaint.
Yes, it is an application. Right? Now coming to criminal complaint. Whether a criminal complaint before a magistrate can be amended. I will give you two judgments. Please jot down that. An application for amendment is maintainable in a criminal complaint also, but in a very limited way. Right? Two judgments are there. One is UP Pollution Control Board. UP Pollution Control Board versus Modi Distillery. MODI, not our Modi. It is 1987, some other Modi. 6/8/1987. UP Pollution Control Board versus Modi Distillery. Right? 6/8/1987. Then SR Sukumar, SUKUMAR. SR Sukumar versus S Sunnad, SUNAAD. SR Sukumar versus S Sunnad Raghuram, RAGHURAM. 2/7/2015. Curable or formal amendments can be made in a criminal complaint also. Okay? Before issuance of summons, and foundational additions cannot be asked in a criminal complaint. All this you should please read. Okay? Next question. Formal amendment. Right? Next question. A girl, an aggrieved person, obtains an order from a court under DVC. In the same house, my mother goes to the collector. Under what act? Which will prevail over which? Why? Because she is a senior. Now you should see the forum. This order is obtained from the court. That order is from an executive person. Now the difference is, my dear, Section 3 of CRPC should be read very carefully. What is Section 3? Section 3 says the difference between two magistrates. Section 3 of CRPC speaks of two magistrates. One is an executive magistrate, another is a judicial magistrate. The duty of an executive magistrate, I think questions also may come from this. Duty of an executive magistrate are to arrest a person and detain him under preventive detention. An executive magistrate can order for preventive detention. Judicial magistrate should order for punitive detention. PUNITIVE. Punitive detention. The word punitive root is punishment. When punishment will come? After? Post trial. Another question. Okay, when does a trial get commenced? After framing of charge. What is the judgment? When does a trial get commenced? You all rightly said after framing of charge. The judgment of the Supreme Court is Barrdc versus State of Punjab 2014 Constitutional Bench. Barrdc versus State of Punjab, 2014 Constitutional Bench says a criminal trial gets commenced after framing of charges. The stage before that is called as inquiry. Understand, my dear? 1861 CRPC, it took lot of years, hundreds of years for Supreme Court to say when does a trial gets commenced. A trial gets commenced after framing of charge. I think some magic is there. The time is over. How long you want us to continue? If you are
9 o'clock.
See, you do not know about me. I will keep on talking. That is, trial gets commenced after framing of charge. My next question is, please read section 353 CRPC. When does a trial gets terminated? Two questions are very important, my dear. In a criminal law, when does a trial gets commenced? When does a trial gets terminated? Please come to 353 CRPC. Please read. Brother, give the mic, brother. Sir, tomorrow you ask some risk student. Yes, he should be active running here and there.
The judgment in every trial in any criminal.
Give the mic, brother. Brother, look at there. He is not looking at women. Your wife is there somewhere. Your wife is there. Oh.
Judgment in every trial in any criminal.
No, it is.
The judgment in every trial in any criminal court of original jurisdiction shall be pronounced in open court by presiding officer immediately after the termination of the trial.
1 second. What she says? Judgment shall be pronounced after the termination of trial. This is 353 of CRPC. Now tell me what is termination of trial as per this.
After the arguments,
Senior is telling after. Once again, read, my dear.
The judgment in every trial in any criminal court of original jurisdiction shall be pronounced in open court by the presiding officer immediately after the termination of the trial.
353 says judgment shall be pronounced after termination of trial. Now, commencement of trial, you all told me that it is after framing of charge. I said after framing of charge, the stage is called as trial. Before that, it is inquiry. Where from? Bail, rejection of bail, cancellation of bail, return of property, framing of charge, everything is called as inquiry. Everything is called inquiry. Before framing of charge, everything is called as inquiry. After framing of charge, it is called as trial. Now, I asked you a question. When does a trial gets terminated? Right? Now, what is your name, ma?
Sriveni.
Sriveni is telling 353 says judgment shall be pronounced after the termination of trial. Immediately. Sir is telling that is after arguments, trial gets terminated. Any other answer?
By delivery shall determine.
Then you are now contravening section 353. What is your name?
Amulya.
Amulya is very intelligent. Her answer is right. 353 says judgment shall be pronounced after termination of trial. But Amulya's sister says a trial gets terminated after pronouncement of judgment.
before trial, judgment.
After, see, I am just telling, ignore 353. There are two laws in this country. One is law made by the parliament under Article 245. Right? Every law in this country is made by the parliament under Article 245 of the Constitution. Under Article 141, Supreme Court declares laws. See, 245 is making laws. These are all very finer aspects. 245, Parliament makes laws. Understand, my dear? State legislature makes laws. Supreme Court declares laws. Supreme Court will not make laws. Under 141, Supreme Court declares laws. Supreme Court says the law is made by the Parliament. I am declaring that this is how it would have been made. 353 says termination of trial, after that you deliver the judgment. Supreme Court says in Sukhpal Singh Kaira, S-U-K-H-P-A-L, Sukhpal Singh Kaira, K-A-H-A-I-R-A, versus State of Punjab, 2020, Sukhpal Singh Kaira versus State of Punjab says, Supreme Court says 2020 constitutional bench. See, one constitutional bench is required for answering when the trial gets commenced. Another constitutional bench is required to say when trial terminates. As Amulya has rightly said, Supreme Court says in a civil law, in a civil trial comes to conclusion, termination of trial in a civil court ends in pronouncement of judgment. How many of you practice in civil side? Only 4. But nobody is raising the hands, very weak. Yes. How many of you has applied for copy application in a civil judgment? All. Whenever you apply for copy application in a civil judgment, one problem you will face. What is the problem? Excellent. I will give sweets to all of you tomorrow. One lazy fool will be there. He will say, Madam, judgment ready aichi. What is not ready? Because Supreme Court judges taking proof from this, they say, termination of trial happens in a civil court on pronouncement of judgment and not decree. I am repeating. Termination of trial in a civil court happens on the pronouncement of judgment and not decree, because Supreme Court judges also knows decree is not made by the judge. It is made by that lazy fellow. Judgment will be ready. He will say decree clerk is not present. Decree is the speaking portion of the judgment. It has to be culled out and put as a decree. For that, no judicial mind is required. Ministerial act. In a civil case, a civil trial gets terminated on pronouncement of judgment. Right? Coming to criminal side. Now tell me, when does a criminal trial terminate? Pronouncement of judgment or sentence? Sentence. Why? For sentence, what is required? Judicial mind is required. See, conviction means, see, Jayalalitha from Tamil Nadu came to Karnataka. Unha judge said, I find you guilty, now you go to jail. 2 or 3 days after I will pronounce the sentence. Judgment finding guilty means the prosecution has proved the case, you are guilty of the offence. This is called as conviction phase, P-H-A-S-E. In a criminal trial, there are 2 phases, P-H-A-S-E. One is conviction phase, another or guilt phase. Conviction phase, P-H-A-S-E, not F-A-C-E. Conviction phase or guilt phase. That is, court will say, you are guilty. They have proved, I am convicting you. Right? Second thing is sentence phase. Now the judge will ask a question, for what punishment this fellow is entitled to? Whether I should give punishment, whether I should impose only fine, whether I should put him in simple imprisonment, whether I should give him rigorous imprisonment, what is the quantum, 1 year, 2 years, 3 years or 7 years? Suppose there are cases like POCSO, which prescribes for minimum sentence. What is minimum sentence?
Yes.
Minimum mandatory. See, the word, whenever I use the word minimum sentence, means judge cannot reduce it. It is called as minimum mandatory. What is the word used? The punishment shall be for a period of 20 years. The punishment shall not be less than 20 years. In that case, you cannot argue in the point of reducing the sentence. Because already the legislature has fixed. One is persuasive sentence, another is determinate sentence. Persuasive sentence means you will persuade the judge in what cases. For a 307 it will say the punishment may extend up to life. What is the lesser punishment you can ask? 1 day. See, if it says punishment may extend up to life, starting point is 1 day. Punishment is for life. Punishment shall be for life means it shall. Punishment may be for 10 years. May extend up to 10 years. If the word is for 7 years, for 10 years, shall be for 10 years, all these are called as minimum mandatory punishments. You understand, my dear? Read 2 judgments to understand this. Rakesh Kumar Pal versus State of Assam, 2017. Rakesh Kumar Pal versus State of Assam. And Shilpa Mittal versus State of Delhi. Shilpa Mittal, M-I-T-T-A-L, Shilpa Mittal. Sir, please sit down. There are 2 chairs. Go that side, don't worry, they will not do anything. Please sit. Kuchundi. Yes, I am right? Yes, I have learned some words from you. Okay, the Shilpa Mittal and Rakesh Kumar Pal, you should understand you should read to understand how to read this for 10 years, minimum 10 years, all this, right? Shilpa Mittal is with regarding to Juvenile Justice Act to understand what is a heinous offence, right? Rakesh Kumar Pal is to understand how section 167 CRPC has to be understood. Because under section 167 CRPC, it says filing of charge sheet. 2 filing of charge sheets are there. One is if the punishment is less than 10 years, charge sheet shall be filed within 60 days. If punishment is for 10 years and above, I am using the word for 10 years and above, then 90 days. For 10 years means it is minimum 10 years. I am once again repeating, if some offence says, for 307 says, punishment may be up to life, it is not for life. Maximum the legislature is telling may extend up to life. That doesn't mean that mandatory life should be given. For 302 there will be mandatory. See 326, read 326. Punishment for 10 years or for may extend up to life. 326 also no minimum punishment is given. You understand, my dear? So please read all these judgments. All these judgments are very, very useful. Now coming to this Suppal Singh Kaira, whenever the court convicts a person, it is conviction phase. Conviction, whether after conviction court should definitely give sentence. If the court finds somebody guilty of an offence, whether court should definitely give sentence or court can pardon and leave. Pardon and leave. Please read section 360 and 361 of CRPC relating to probation. All these questions will come. Every conviction need not be followed by a sentence. Certain cases not involving offences against women and child, economic offences, right? Socio-economic offences, offences not relating to women and child, then probation can be given under section 360 or 361 of CRPC. If Probation of Offenders Act 1958 is applicable in Telangana, then 360, 361 of CRPC should not be applied. I am repeating, if Probation of Offenders Act 1958 is applicable in Telangana, is it applicable in Telangana? So you should read the judgment of Chani versus State of UP, CHANNI versus State of UP. Chani versus State of UP. That judgment says, why, my dear, if Probation of Offenders Act has come, then CRPC is not applicable? Daughter-in-law has come, mother-in-law should not be there. Understand? Any special law comes, then mother-in-law should keep the mouth shut. Okay. Johnny versus State of UP says, Probation of Offenders Act, if it comes into force, read section 19 of Probation of Offenders Act. It says, brother, until what, which time you should move? 6. You close by 6.
Right.
See, if you are interested, please let us continue. See, now secretary's words are of no use. They are the boss.
They are appearing for it now.
If you are interested, if the transport is not a difficult thing, we will continue up to some time, right? I am also not interested in closing the class. Right? I am here, he has spent lot of money taking me here. So I will be there. If you want, we will continue. Let us not finish it. Okay? Yes. Okay. Where did I leave? Please read. Questions are also possible. Probation can be given, right? We will touch that act also. Probation of Offenders Act 3, 4 and 5 should be read. 3, 4 and 5 are very important. 3, 4 and 5 says 1958 Act says to whom probation is applicable. It is applicable to a person, okay? Probation of Offenders Act is applicable to a person who attains the age of 21 on the date of conviction. Right? On the date of conviction, he should be 21. Ramji Misar versus State of Bihar. Please read the judgment. Ramji, R-A-M-J-I, Ramji Misar, M-I-S-S-A-R versus State of Bihar. It's a 4-judge bench of Supreme Court. Ramji Misar versus State of Bihar. It says, see, I am telling you like this, my dear. Juvenile Justice Act, there is a age limit. What is the age limit? 18. On which date it should be 18? On the date of commission of offense. Okay, not on the date of conviction. Now you read the board, Muniandi Villas, or what is that? What is the NV hotel here? Chettinad Mess, something like that. Read the words Probation of Offenders Act. It is not Probation of Accused Act. When a man will be declared as an offender, by whom? I have told you, just now I told you, a man will become convict after a trial. After the completion of trial, a man will become a convict. Otherwise, he is called as an offender on that day only. Prior to that, he is an accused. Now read this, Probation of Offenders. On the date of section 6. Section 6 says, whenever a court convicts a person, finds him an offender, on the date of pronouncement of the order of conviction, if he is 21 years, court should definitely give him the benefit of Probation of Offenders Act. That is, he should not be sentenced immediately without discussing why I am sentencing him without probating him. You understand, my dear? Section 6 is an injunction to court. That is, if any person is below 21, on the date he is declared as an offender, then section 6 is an injunction. Deciding date is on the date of conclusion of trial, that is, he is declared as an offender. See, only a court of law can determine a person that he is an offender. Otherwise, he remains only as an accused. Right? Now we will go back to our Sukhpal Singh Kera. What happens in Sukhpal Singh Kera and in Hardeep Singh also, you should read section 319 CRPC, because that is also an important question will come in exam. What is 319 CRPC? Any person can be arraigned or added as an accused. Now, Hardeep Singh says, what is the stage in which he can be added? Sukhpal Singh says whether after conclusion of a trial, any person can be added as an accused. For that, they have to determine termination of trial, right? Now, Supreme Court says in Subpal Singh Kera, that is a person can be, whether in what stage he can be added as an accused, right? Whether after the trial is over can be added as an accused or not. Supreme Court says the moment the trial is terminated, court becomes functus officium. So if at all any person has to be added as an accused, it should be done before termination. After termination, court becomes functus officio. That means they cannot do that act. Court is seized of the matter. It cannot do anything. Okay, my dear. This is Subpal Singh Kera. It says in a criminal court, in a criminal law, in a criminal trial, termination of trial takes place the moment an acquittal is ordered. Termination takes place. Termination of trial takes place not on the pronouncement of conviction, but on the pronouncement of sentencing. Because sentencing, unlike decree, it requires a judicial mind. What is the sentence that has to be given? Okay. So now we will come to domestic violence once again. Where did I leave you? In Vanita's case. In Vanita's case, I said Domestic Violence Act is a trial before a magistrate. From there we went to all this way, right? And I asked you a question whether Senior Citizen Act will prevail or Domestic Violence Act will prevail. You all said Senior Citizen Act. Supreme Court is telling because it is a trial before a court of law, this will prevail as against a magistrate. Then I asked you a question, where is the distinction between a magistrate, executive magistrate and a judicial magistrate? We went to the word punitive punishment. For this only all this travel we have made. Duties of an executive magistrate is preventive detention and issuance, renewal, cancellation of license. Issuance, renewal, cancellation of license. Coming to this side, duties of a judicial magistrate is to sift the evidence. SIFT. Sift the evidence. See, previously, some 10-15 years back, in all the homes, there will be a circular thing. You will put all this ration shop, maida and rava and all. All insects will be at the top of it and rava will go down. You will do like this, no sifting. What you will say for that? Salada. Tamil also is salada. Say, thank God. This process is called as sifting. Now the poor magistrate, judicial magistrate, one fellow on the accused side, full liar, another side prosecutor like me a liar, both of them will reveal all lies. This poor judge should sift the evidence and to find out the truth. That is separating the chaff from the wheat. Understand, my dear? The duty of a magistrate, judicial magistrate, is sifting evidence and concluding. If he concludes that this fellow is the criminal offender, then he gives the punitive detention. On the other side, that is a person who on apprehension imposes a preventive detention order, and apart from that he collects revenue. Apart from that, issuance, renewal, cancellation. Okay, these questions may be asked. Okay, yes. And whenever in CRPC or BNSS, the word magistrate is used, please understand all this very carefully. Wherever the word magistrate is used, it refers only to judicial magistrate. Unless a qualified word executive is added. What is a qualified word? Red hat, black shirt. Like that, if in CRPC the word executive magistrate is added, then only it refers to an executive magistrate. Or else, any word magistrate used in CRPC refers to. If the question paper is very tricky, all this will come. Okay? We do not know who is going to challenge whom. You can also challenge the examiner. God knows. See, now I will come to the DVC. I thought of finishing DVC and the Pope. See, until this time you have understood everything, no? Yes, there is no doubt. Yes, I want to do justice to the subject. I don't want to just run like a small, what is this, anil. What is anil? Squirrel. You know how a squirrel will run? Yes, the moment you see it will run like this. That's all. Right? Now, I have asked you a question whether the orders passed under DVC will prevail or the order passed under senior citizen. Answer is the orders passed under DVC. Yes, Vanita. Yes, Vanita versus the Deputy Commissioner, 15/12/2020, Supreme Court. Full bench, 3 judges. Yes, Vanita versus the Deputy Commissioner, 15/12/2020, Supreme Court, full bench. Okay, now please come to 21. I am going to ask you a very tricky question. We will see who is very intelligent. I am not going to listen to you. My brothers, 21 says custody orders. I will read. Question is whether a husband can ask for an interim custody. We will read 21 now. Answer is yes, we will read 21. Right? To be an aggrieved person, it should be a woman. Only an aggrieved person can be a petitioner. Right? Section 12 says application by aggrieved person. We will come to 23. 23 says in any proceedings before him under this act, magistrate may pass such interim order as he deems fit. Right? 12 says applicant is, 2 says aggrieved person is a woman. 12 says application to magistrate by an aggrieved person. My question is whether a husband can ask for, what an husband can ask. He cannot ask for maintenance in this. The only trouble he can give is, whenever the wife comes to maintenance, husband will say, no, I love her so much, I will take her. You file a maintenance application, the love of the husband will be too much. And a warrant, no, non-payment of maintenance, 125(3) warrant, then the love will be so much. He will come and hug her, he will take some gift and all. Previously, he will not do. And any woman who comes for a maintenance, the husband will immediately say, no, ask her to give the child. I will grow up the child. Then he will ask for a visitation right, custody this thing. My question is, when DVC 2A says, aggrieved person is the petitioner, whether the husband can come and ask for custody under 21. Now we will read section 21. Notwithstanding anything contained in any other law for the time being enforced, it has thrown out all the other laws. GOP law, adoption laws, all this, right? Notwithstanding anything contained in any other law for the time being enforced, the magistrate may, at any stage of hearing of the application for protection order or for any other relief under this act, grant custody, temporary custody of any child or children. Now comes the tail with string. To whom? 2A says, who is the aggrieved person? Yes, my dear. 21 says, temporary custody of any child or children, granting it to the aggrieved person or, see, the person making an application on her behalf. On her behalf. Father, grandfather, but he should represent the interest of aggrieved person. Brother, see, 21 says, interim custody can be sought, can be granted only to aggrieved person or any person who files on behalf of the aggrieved person. As senior has rightly said, on behalf of aggrieved person, a man can come. Suppose the aggrieved person is bedridden, the father can come, son can come, right? Now, my question is whether interim custody can be sought for by the husband telling that my wife has the child, give the child to me. No. Right? The answer is no, that is correct for a moment. Right? We will read then. Or the person making, and if necessary, the arrangement for visit of such child or children by the respondent. Then down is, provided if the magistrate is of the opinion that any visit of the respondent who is a respondent, aggrieved person will file against a respondent. May be harmful to the interest of the child or children, magistrate shall refuse to allow such visit. So if the aggrieved person, lady, has the child, the magistrate thinks even that visitation by the respondent is harmful, he can deny. Now this question is pending before the Supreme Court because there are lot of you all said yes. Supreme Court is asking one question. What is that question is, suppose if husband comes and file an application for interim relief, custody or visitation, you say that you cannot be a petitioner reading 21, will he not go and file an application before a family court or a district court? Whether this lady will not be running from pillars to post. In the interest of the lady, should it not be conceived that husband also should be permitted to agitate? You understand, my dear?
Yes.
In the interest of aggrieved person, Supreme Court is asking, should we strictly interpret section 21 and say whether she alone should be the petitioner, or if he comes for some relief, we will decide it here or not. The question is pending before the Supreme Court in Hemant Babu Rao. Whether husband can seek for interim custody in DV proceedings. Question is pending before Supreme Court in Hemant, H-E-M-A-N-T. Hemant Babu Rao, B-A-B-U-R-A-V, Vasante, V-A-S-A-N-T-E. Hemant Babu Rao Vasante versus State of Gujarat, 6/3/2024. Yes. I have told you, citing Arun Daniel, what did I say in Arun Daniel, Monica and Padmanabhan's case? Magistrate need not issue summons for everybody, need not frame charge, he can amend everything I said. Right? I told you, a criminal court, if a criminal magistrate in the criminal proceedings, he cannot recall. He cannot review his own orders. Right? Under CRPC, a magistrate has no power to recall his own order or to review his own order. Right? I will tell you the judgment. Magistrate cannot drop the proceedings because there is no provision. You can make a topic. A magistrate cannot drop the proceedings in a criminal proceedings. A magistrate cannot drop the proceedings. Once he has initiated something, he should follow that. Right? He cannot drop the proceedings. This is in the case of Adalat Prasad versus Rooplal Jindal. Please read all this. These are all very important judgments. Adalat Prasad versus Rooplal Jindal and others. 25/8/2004. Adalat Prasad versus Rooplal Jindal and others. Supreme Court, 25/8/2004. Then the same year, Subramaniam Sethuraman versus State of Maharashtra. Subramaniam Sethuraman, S-E-T-H-U, Sethuraman versus State of Maharashtra, 17/9/2004, full bench. These two Supreme Court, these two judgments says, if a criminal court passes an order, it cannot recall, it cannot review its own order. However, in DVC, we said in Punnappa Reddy and in Arun Daniel, we have told you that because it is not a criminal court, even if it passes an order, it can revoke, it can modify the order. Are you aware, my dear? But this thing should not be extended to a criminal court. Rooplal says, Subramaniam Sethuraman says, once an order is passed in a criminal court, it is passed. You should either prefer a revision or an appeal. Okay? All these are basic, essential things. Okay? Yes, I will ask you another one question. We were talking about elaborately about this conviction. When a criminal court will give a conviction?
Beyond reasonable doubt.
Excellent, my dear. Excellent. You be louder.
Beyond reasonable doubt.
He is using a word. I asked you a question. When a criminal court will convict a man? He said, if the prosecution, what the judge will write, all criminal judgments, last para there will be one word in the last para. the prosecution has proved the case beyond all reasonable doubt, I am convicted and sentencing. Ulta, for acquittal, prosecution miserably failed. Senior is using the right word. Or prosecution has not proved beyond reasonable doubt. My question is, chocolate is ensured, I will give you a chocolate. Right? My question is, in which law the word, whether in CRPC, BNSS, criminal rules of practice, IPC, evidence, central class, you should now give me chocolate back. Minus marking. Whether APP exam has got minus marking. Yes. All wrong answers, chocolate should come. When I am going to Tamil Nadu, I will go with a suitcase of chocolate. My question is, in which law this concept is used? Prosecution should prove the case beyond all reasonable doubt. Tell me. Evidence. Show me. You are having evidence at book. Tell me. Tomorrow morning come and tell me. I will tell you, no law says that the prosecution should prove the case beyond all reasonable doubt. Second, I am asking you another one thing. Which law says the accused shall be presumed to be innocent unless and until his guilt is proved?
These are general principles.
Which law? Which law? Which jurisprudence? You are going to face an exam. This is not sitting in tea shop. Right? We are going to face an exam. I told you two things, my dear. One is first principles made by Parliament. Second is Article 141, Supreme Court. Article 142, there is another one, Article 142. Supreme Court can frame rules, not act. Act making is only the work of Supreme Court can make rules. Supreme Court has made a rule before a Posh Act. Which case law?
Vishaka versus State of Rajasthan.
Excellent, my dear. Vishaka versus State of Rajasthan, 1997 Supreme Court. Under 142, they made a rule. Note it down. Before the Posh Act, you know what is Posh Act? Sexual harassment of women in workplace. Posh Act 2013. Before that, Supreme Court has issued guidelines for working women to protect them from sexual harassment in Vishaka versus State of Rajasthan, 1997. Right? 2019, invoking Article 142, Supreme Court in Ritesh Sinha versus State of UP, Ritesh, R-I-T-E-S-H, Ritesh Sinha versus State of UP, 2019, Supreme Court invoking Article 142, it framed rules for taking voice sample test. To take voice sample test, there is no law in this country. In new BNSS it is there. Old CRPC, Supreme Court invoked 142 and said all magistrates, police can seek for permission of the magistrates and take voice test. Suppose today evening I am calling Nalini and threatening. She will immediately go to Rangareddy police station and complain. And I will tell, no, I have not threatened her. I will say, and if police summons me and asks me for a voice test, I will say there is no law compelling me for a voice test. This was from 1861, all this drama was there. No law. Supreme Court in 2019, Ritesh Sinha was a State of UP, invoked Article 142, made a rule. Then, Mahendra Chavla versus Union of India. What for? Mahendra Chavla. Mahendra, M-A-H-E-N-D-E-R. Mahendra Chavla, C-H-A-W-L-A versus Union of India. Invoking Article 142, Supreme Court made a scheme called as Witness Protection Scheme of 2018. Witness Protection Scheme. You should read all this. All these are very important topics in criminal law, my dear. Okay. Witness Protection Scheme. Now we were talking about various schemes because whenever law is deficit, Supreme Court under 142 says, in order to render complete justice, we cannot shut the ears because we are the apex court and say, no, law is deficit, we will not do anything, our hands are tied. Supreme Court will evolve rules because they are the apex court, ultimate court, they should do complete justice. They cannot evade telling that no, there is no act. You understand, my dear? Yes. Like that, my question is, there is no law in this country which says accused shall be deemed to be innocent unless the guilt is proved. Secondly, no law, criminal law says prosecution shall prove the case beyond all reasonable doubt. One judgment of House of Lords 23/5/1935, 23/5/1935, House of Lords in Wilmington versus Directorate of Public Prosecution, Wilmington. Wilmington versus DPP, Directorate of Public Prosecution. It is a judgment of 23/5/1935. The question is whether these two principles, that an accused shall be presumed to be innocent until otherwise is proved, whether this one principle, second principle, whether the burden should be on the prosecution to prove the case beyond all reasonable doubts, whether these two principles should be ingrained in a criminal law for Commonwealth countries. This is the question. What are Commonwealth countries?
India.
India, poor Africa, poor America, in the hands of rich British. Right? Our grandfathers chose themselves to be slaves to those fools who ruled this country for 300 years shamelessly. Right? Even if our grandfathers had gained energy to take one stone each and thrash those fools, no, they would have gone. They have exploited this country. Right? And this 1935 House of Lords, Commonwealth countries should follow this as essential principles of criminal law. This is a House of Lords judgment that every Commonwealth country in a criminal trial should follow these principles. You understand, my dear? Wilmington issued this. House of Lords in Wilmington issued all criminal courts should follow these two principles. And after attainment of independence in 1947, Supreme Court is following these two principles. That is the reason it has gained the force of law. Suppose tomorrow Supreme Court says, no, we are not going to follow this. Then, in addition to this, I will tell you only one provision from Evidence Act. Section 101, illustration small a. It says, if prosecution alleges something, if A beats B, right? A is beating B. B says A has beaten. Burden lies on A beats B. B is the complainant. Evidence Act section 101 illustration small a says B should prove. Not all these drama words, ornamental words, beyond reasonable doubt and all is nowhere but for Wilmington versus DPP. You understand, my dear? So this is the basic foundation of criminal law. We are following these principles, right? Another one question. We are talking about criminal case and civil case. CASE. The word case. If you are absent, the judge will shout. When case is called, you are not there. What, he will write a diary, no? When the case is called? No representation. Second question is, where is the word case defined? That every day you are using. If Nalini becomes a prosecutor, she will handle criminal case. If somebody asks Nalini, where is the word case defined, Nalini? CAC. You should every day question it. Each word you use, no, you should question where it is. Answer is there. In which law? Word case. General classes, evidence, CRPC, new laws. Where, ma? You should bring chocolate back. It is not there in general classes. Amulya is going to purchase chocolates tomorrow. In Bimmappa Basappa Bhusanavar versus Lakshman Shivarayappa Samagowda. Telling a case law, why are you laughing? In Bimmappa Basappa Bhusanavar. Bimmappa. It is our brother from Karnataka. Bimmappa Basappa Bhusanavar. BhuSanavar. In Bimmappa Basappa Bhusanavar versus Lakshman Shivarayappa Samagowda. Lakshman Shivarayappa Samagowda. No, Karnataka. Bimmappa Basappa Bhusanavar versus Lakshman Shivarayappa Samagowda. 1970 Supreme Court. Full bench. Supreme Court said beautifully, the word case is not defined in any law. I am asking you, no, you should have said it is not defined in any law. Supreme Court said the word case is not defined in any law. However, in criminal proceedings, the word criminal case should be understood as a process which ends either in a discharge or in an acquittal or in a conviction. Supreme Court has defined the word case that the word case is not defined in any law. However, in criminal parlance, a criminal case should be understood as a process which ends either in a discharge or in an acquittal or in a conviction. Okay? I think we will conclude. You all should come tomorrow morning, no? Yes. Because I could sense some mind voice from my secretary. Right? Yes, we will, for 10 minutes you can ask me some questions. Don't ask anything regarding this and this. Right? Otherwise you can ask me any questions. Tomorrow morning by 9:30 you all will come, no?
Yes, sir.
But please don't come late. Right? We are still halfway in DV. Domestic violence. Well, I thought of finishing DV today. But see, you are going to face exam. It is not like bluffing and going. Right? And now I think all the concepts are very sure.
Yes, sir.
Yes. Huh? If DV somebody asks questions, he will tear the paper. Huh? No, I'm honestly asking whether the 3 to 4 hours is useful.
Yes, sir. Yes, sir.
No, you have understood the concepts, no, my dear? Yes, sir. Yes, okay. That is enough. Instead of running, no, with no explanation of concepts. Okay, we will have 10 minutes. Kindly ask any questions in which we have dealt now. Yes, ma'am. Please come with the mic, dear.
Part of the reasonability and probabilities and presumption until reach the not the justice. If any guarantee is there, I touch the justice by clean hands. The broad sense of 7 decades past the Constitution, if any guarantee or scope in the justice.
What do you mean by that? What guarantee you want?
Until I touch the justice with clean hands, the many of the common persons not reach the justice today.
So who should protect it? Who are the saviors for justice?
What I mean to say is that if any scope or law, broad
You can
sense,
tell in the mother language, he will translate, sir will translate.
any broad sense of the Article 14 or Article 21 give the compulsory touch the justice of the common man.
See, I will tell you one thing. I do not know whether I have understood the question properly. You just do.
ఐచ్ఛికత కాకుండా ఖచ్చితమైన జస్టిస్ పొందుతారని నా భారతదేశంలో నాకు నమ్మకం ఉన్నదా? ఈ రీజనబుల్ డౌట్స్, ప్రాబబిలిటీస్, ప్రిజంప్షన్స్ కాకుండా నాకు ఖచ్చితమైన ఇట్లా ఫండమెంటల్ రైట్ లెక్క ఉన్నదా స్కోప్ అనేది 14 లో కానీ 21 లో కానీ?
You are not scolding me, no?
No, sir.
Scolding the entire system.
Yes, sir. Yes, sir.
Entire system, whether it is possible or not.
Because I am the citizen of India and the taxpayer, but I am no guarantee at all that I touch the justice.
No, I will tell you the answer. Let's ask, sir.
Her question
Please
is
listen, please listen.
that we are dealing with presumptions and maybe some assumptions also. As the constitutional fundamental rights as 14 and 19 guarantee, whether one person shall approach them or take advantage of it without these presumption and assumptions, is it not a fundamental right? Whether such a process is available in Constitution? Adana madam?
See, there is a article called as Article 21. Okay? We all believe that Article 21 gives you the protection of life. If anybody asks you a question, what is Article 21? Then what is the answer? Right to life. Right to life and personal liberty. Now I will take you to 15/6/1215. 15/6/1215. 15th June 1215. Magna Carta. Right? In that there are two articles, Article 39 and Article 40. Please Google it and see in the home, not now today, you are packed, no? Yes, 15/6/1215, one book by name Magna Carta came, Article 39 and 40. Article 39 says, right to liberty and possession of property, not right to life. You understand? Right to liberty and possession. I will understand that provision like, now 21 says right to life. During 1215 people are not worried about life, or they have a guarantee that my right to life will not be disturbed. They want only liberty, or they value liberty more than life. Right? Then they want possessory right of property. Right? In our constitution, Article 21 says, no person, it is couched in negative. It starts with a negative. Certain provisions notwithstanding anything, provided like that, Article 21 starts with, no person shall be deprived of his right to life and personal liberty except in accordance with procedure established by law. Remove this no and remove this except, two negatives. Right? How do you say that? Every person shall be deprived of his right and personal liberty in accordance with procedure established by law. Nalini goes and gives a complaint as against Chandru. Right? A cognizable offence. Police comes to my house. Till now I am enjoying right to life and personal liberty. If she sets the law into motion, police comes and says, you come to the station. They take me to the magistrate. Magistrate says, I am putting you in jail for 15 days. Bail court is telling, no, we will not grant you bail. The offence is very grave. Wilmington versus DPP says, unless and until a person is proved guilty, he shall be presumed innocent. Bail law says, no, the prima facie there is material. You be in jail. If you are let out, you will hamper the investigation, you will tamper the witnesses. Now see, without this man being declared as guilty, now we are telling you be in jail. For grievous cases, for grave offences, for UAPA, NDPS cases, for PMLA cases, 3 to 4 years they will be in jail. You move any amount of bail application, offences are grave in nature. It is not proved. Trial was not yet started. However, court has said to regulate the system, society, suppose I killed this person. Tomorrow morning I come out stating that I should be presumed to be innocent unless I am proved guilty. What this man and this man's people will do? After killing, suppose I am not there for in jail for 3 to 4 months. Next day I come out, what his people will do on me? They will attack immediately and kill me. In order to maintain some balance, the bail court says the offence is grave. Let him be in jail for some time. Let the heat and passion of those persons come down. So, every act in this country, even if you put me in jail, if you put me in noose, that is also in accordance with Article 21. Right? Right to life is not guaranteeing you absolute right. Every right in the country will have its own duty, corresponding duty. I have a right to walk like this. And if Nalini walks behind, she has also a right to walk. If I stop,
She put
her right is put to bar. You understand, my dear? I can see in a road, A car should go, B car also should go. I cannot say it is. I have paid road tax. I have got a right to move in the road. Right to move also includes right to not move. I cannot say. My right to move has a duty of permitting the person behind also to move. So 21 says your right to life and liberty will be preserved, protected if you act yourself as a citizen worthy of living. If you commit crime, if you commit a violence, then your right to life and personal liberty will be taken in accordance with law. However, section 21 guarantees a dignified life. You can read one judgment, you can read today night and come. Shatrugana Chauhan, Shatrugana Chauhan, SHAT, Shatrugana Chauhan versus Union of India 2014. Shatrugana Chauhan versus Union of India 2014 Supreme Court. I think it is a full bench or constitutional bench judgment. Article 21 says a man has got a right of dignified death also. 21 says we will remove your life. See, Nalini is killing Chandru. Case proved. Court is giving Nalini a death sentence. But Nalini is still entitled for a dignified death. What is dignified death? In that Supreme Court says you should not strangulate her and put her to death. You should break the neck and make her die. You understand, my dear? Shatrughan says a person who is hanged by law, they don't strangulate you and make you die. Strangulation will take long time. They will displace this neck and this spine. It is like this, no? There is a noose. You can see lot of this thing. It will push your neck and the body separate. Such that you will die within 7 seconds. 7 seconds. Suppose if Nalini is strangulating me, it will take 1 or 2 minutes to die. Even in death, I should be enjoying a dignified death. After putting a man in noose, my body will be subjected to a post-mortem and the doctor will write whether Chandru has died a special death, that is strangulated death, or the spine and the neck is displaced. And if I am strangulated, the noose man who is doing that. Yes. He will be punished for that. Shatrughan Chauhan says that hanging a man is the dignified way of killing. They have discussed whether firing or putting injection, which is the mildest way of killing a man or decent way of killing a man. Because in America, they put a cocktail injection, not this cocktail. You know what this cocktail? Mixing all the matters together and enjoying and vomiting. Right? In America, they mix all poisons, 3 to 4 types of poison and put an injection. In that also, death is not very immediate like displacing. It takes seconds together. In some countries, they fire. That also they don't die immediately. See, example is, if somebody has grown this hen or chicken, no? In olden days, they don't go to the shop and purchase it. Now, if you go to a shop, they will put it like this and cut, and that hen will do all these dramas. In olden days, what they will do, they will catch it nicely. It will come, no, it is also like a child for us. It comes thinking that you are going to do some, yes. They will just break the neck like this. Immediately it will die. They will not strangulate, they will just remove the neck from the, like that Shatrughan Chauhan says, you displace it, death also should be dignified. Why I said all this is, right to life is inherent, but if you damage a right to life or personal liberty of others, law will also put its inroads into this. Okay, we'll continue the class tomorrow. And talking like this is very easy. Sitting and listening is very difficult. Okay, thank you so much. All credit should go to my senior.